Lord, I may pardon, my lord. One mention, my lord. CRLA 47 of 2014 may be listed next week. 14 years in custody.
All right.
God bless you.
Weekly list item number 1.
It's, so far as my main thrust was on the affair, I only point out one line. PW8, the person who scribed the affair during the timing of the affair, though it is stated that it was ready, held at 4:20, but the scriber gives a different picture. PW8, it begins from page 94, but I'm placing para 5 at page 96. Page 96 minutes. First paper. Lordship got it. Yes. He is the uncle of Giridhari. Means informants Mamu Sasuro.
Yes, which line you want to say?
Page 96, para 5. He is the scribe. Phone call had come to my sister in between 3:30 to 4 p.m. on 21/10/2020. After 10 minutes of the receipt of the phone call, we left for Lapada. I cannot say the registration number of the Bolero in which we came to Lapada. Altogether, 6 persons, including the driver, came to Lapada. I had not informed this incident to any of my relatives. It is not a fact that on the way to Lapada village, Gimiria, village Saida Falls, village Lapada is about 50 kilometers distance from village Kirmiria, where he stays. We reached at village Lapada around 5 p.m. to 5:15 p.m. near about 50%. So he arrived, the scribe arrived at 5 to 5:15 minutes. Then the next page 97, the second line. It is a fact that except Monica Pruset, the informant, I had not heard any other person. 97 ର second line. It is a fact that except Monica Pruset,
that is PW1.
Again, informant, I had not heard from any other person that accused Nabun Deuri and Hemanda Deuri killed the deceased persons. Next para. The affair was submitted to IIC Mohulpally police station by Monica Pruset at the spot. I cannot say at what time Monica Pruset submitted the affair to IIC, but I had scribed the affair before 6 p.m. Around 5:20 p.m., Monica Pruset told me that the accused persons have killed the deceased. So the affair allegedly submitted at 4:20 is an impossibility. 50 kilometers he traveled, reached 5:15. Thereafter, the informant explains the incident to him, and the affair lost thereafter.
Just go to the IO's evidence.
IO 420 minutes.
On this particular point, what he has stated and how far you have cross-examined the IO.
No, this is an admission minutes.
Who's the admission?
This in cross-examination, you have elicited something. Now, suppose the IO says that I received the FIR at 4:20 in the village, and you have not challenged that this was the FIR. So then, Are?
I don't think that has been challenged.
In that case, any answer is taken from a witness has to be taken as admission.
ଏତିକି କରିଦେଲେ ଆପଣଙ୍କର ଇଏ ହେଇଯିବନି, ଆପଣଙ୍କୁ ଆଇଓ କୁ ପଚାରିବାକୁ ପଡିବ, କାରଣ ଆଇଓ କହିଛି ନା ମୁଁ 4:20 ରିସିଭ୍ କଲି. Is the person who has received. ତାକୁ ନ ପଚାରିଲେ are you sure IO has not been questioned on this aspect?
No,
IO is PW20 ପରା କହୁଥିଲେ।
What part of the statement of PWE has been converted to the IO?
ନାଇଁ ତା ଡାଇରେକ୍ଟ କ୍ୱେଶ୍ଚିନ୍ ନହେଲେ PW8 with reference to ଯେ ଆପଣ ଯୋଉ କହୁଛନ୍ତି 4:20 ଏତେଲା ଆସି ଭିଲେଜରେ ଗ୍ରହଣ କଲେ ଏଇଟା ମିଛ କଥା। ଏଇ ଏତେଲା ଆପଣଙ୍କୁ 6ଟା 6:30 ପରେ ହେଇଛି, ସେଇଟା ହଉଛି ଡାଇରେକ୍ଟ ସଜେସନ। ବଟ୍ ଅଦରୱାଇଜ ମଧ୍ୟ ଜିନିଷ ଆଣିବାର ଥିଲା। ଆପଣ କେତେବେଳେ ଇନଫର୍ମେସନ ପାଇଲେ, ଷ୍ଟେସନ ଡାଏରୀ ଏଣ୍ଟ୍ରି କରିଥିଲେ କି ନାଇଁ, ଏ ଗାଁକୁ ଆସିବା ପୂର୍ବରୁ ଗାଁରୁ ଡିଷ୍ଟାନ୍ସ କେତେ, କୋଉଥିରେ ଆସିଲେ, ତ ଦ୍ୟାଟ ଇଜ ଦି ୱେ ହାଉ ୟୁ ମେଡ୍ ଆଉଟ୍ to say that no, the IO cannot reach this village by 4:20 to receive the FIR. ଏ ଟାଇପ ର ହେଲେ ଗୋଟେ ଜିନିଷଟାକୁ ଆସିବ ଯେ ନାଇଁ FIR ଯୋଉ ସମୟରେ ଇଏ କହୁଛନ୍ତି ଲଜ୍ ହେଇଛି ବୋଲି ପ୍ରସିକ୍ୟୁସନ ଆକ୍ଚୁଆଲି ଏଇଟା ସେ ସମୟରେ ହେଇନି, ତା ପରେ ହେଇଛି। ଇଟ୍ ହାଜ ବିନ୍ ଆଣ୍ଟି ଟାଇମ୍। ଓକେ, ସେ ଜିନିଷ ପଚରା ହେଇଛି କି ନାଇଁ ମୁଁ ସେଇଥିପାଇଁ ପଚାରିଲି।
134, that is some reference. Page
Para
130, 26.
Para 26. I reached this spot before 4:20 p.m. It is not a fact that the FIR reveals that at 4:20 p.m. I made the station diary entry. I registered the FIR at 1:28 a.m. It's not a fact that I started investigation.
Obviously ଏଠୁ ଗାଁରୁ ଯାଇକିନି ସିଏ ରିସିଭ କରିଦେଲା ହେଲା, କିନ୍ତୁ ରେଜିଷ୍ଟ୍ରେସନ ସବୁ କାମ ସାରିକିନି
Registration is different. It is not a fact that I started the investigation before registration of the FIR. Means
It is
the
not.
preliminary registration. He made a
Yes,
station diary entry.
it is not a fact
That reference is there in the inquest report.
ନାଇଁ ନାଇଁ ଏଇ ଯୋଉଟା ଆପଣ କହୁଛନ୍ତି ତ, ଯୋଉ ଯଦି ସେ ପର୍ଯ୍ୟନ୍ତ ରେଜିଷ୍ଟ୍ରେସନ
Scribe
ହେଇନଥିଲା
ଆସିନଥିଲା till 5.
ତାହେଲେ ଇନକ୍ୱେଷ୍ଟରେ କେମିତି ନମ୍ବର ପଡିଲା, ସେଇଟା କଣ କି ସେମାନେ ଅର୍ଡିନାରିଲି ବୁଝି ଦିଅନ୍ତି ଯେ ବର୍ତ୍ତମାନ ପର୍ଯ୍ୟନ୍ତ କେତେ PS କେସ୍ ରେଜିଷ୍ଟର୍ଡ ହେଇଛି, ତ ନେକ୍ସଟ PS କେସ୍ ନମ୍ବର ଉଡ୍ ବି ଦିଅ, ଆକର୍ଡିଂଲି ସେ ପକେଇ ଦେଇ ଚାଲି ଯାଆନ୍ତି। ତାପରେ ଆଚ୍ଛା ସିଏ ସ୍ପଟ ରୁ ଫେରିବା, ସ୍ପଟ ରୁ ଯିବେ ପୁଣି ଆଉ ଥରେ ଆସିବେ ସେଠି ରେଜିଷ୍ଟ୍ରେସନ ପାଇଁ
No,
ordinarily
that's he has said. We usually don't carry the register, so he made a station diary entry. Then
ଷ୍ଟେସନ ଡାଏରୀ
went back
ଏଣ୍ଟ୍ରିଟା
and
କରିକିନି ଜାଗାକୁ
PS
ଆସିବେ।
case number. I am not on that. That if this is accepted, so the question was before even FIR was registered, means the stationary entry was even before it was made. The investigation has started.
ସେଇଟା ଗୋଟେ ଲାଇନ କହିଦେଇଛି, ବଟ୍ ଅର୍ଡିନାରିଲି ଏସବୁ କେସରେ
That
କଣ
is all, Millers. There is no other
ସେ
further process.
ଯେତେବେଳେ ସିଏ ଆସିଛି ସ୍ପଟ କୁ
No,
ପହଞ୍ଚିଛି
it's not
FIR
the way your lordship
ହଁ
expects
କାରଣ
it. It's not there.
ହଁ କାରଣ ପୁଣି ଆଉ ଥରେ ଯିବ ଥାନାକୁ
No,
ରେଜିଷ୍ଟର କରିବ, ପୁଣି
there
ଆସି
is no problem,
Huh.
no issues. She says that.
Huh.
She says that we don't carry those. Immediately, I was on my way, patrolling duty.
Yes, he was on
Patrolling duty. She
Huh,
comes.
obviously,
Stationary entry she has made. The question is whether stationary entry was made by then. This present affair was with him or not. That
ସେଇ
is what.
ସେଇ ଜିନିଷକୁ ମଧ୍ୟ ସେ ଯୋଉ NDPS ଆକ୍ଟ ର 42 ପ୍ରୋଭିଜନ ନଥିଲା କି, ଯେ ତାକୁ ସେଇ ଟାଇପ ର କହିଲେ ଯଦି ବାଟରେ ଯାଉଛ ତମେ କିଛି ଇନଫର୍ମେସନ ଆସିଲା, it is not necessary to reduce it and to you
to inform us
proceed,
superior.
complete that, then you come, and that will be also substantial compliance of 42.
Yes.
Exactly same thing.
No, I am not on why it was not registered there or PS case number was not given. The stationary entry it started, nothing wrong about it. But if the scribe's evidence taken with some cross-examination is here,
such answer in the cross-examination is taken as if it is a matter between a trained lawyer and a rustic village. So it is an unequal battle between the two. So at any point of time, such an answer could be possible. So
Millers,
this
at times,
is to be read in totality of the evidence.
At times, when initial days, now it has become more commercial. When NDPS Act came in force, early 90s when we joined, Millers, here when a tribal illiterate person comes as a witness, the discrepancies are ignored that he is illiterate, he is a tribal. But when a tribal person carries a bhara of ganja, ignorance of law is no bliss, he is convicted.
No, no, no. He
So,
knows that this is a contract.
no, nothing to do with this case. Because this is a huge difference in
Obviously,
in the eyes of law.
Yes.
They still live in a different world. Expecting them to know law is
Now,
far away.
and let us say if your contention is also accepted, let us go to that extent. ଯେ ଏଇ ଯୋଉ ଲୋକଟା ସ୍କ୍ରାଇବ କଥାକୁ ଯଦି ଆକ୍ସେପ୍ଟ କରାଯିବ, ନାଇଁ ଏଇଟା ଆଜ୍ଞା 6ଟା 4:20 ଏଇଟା ହେଇନି,
ପରେ
ଏଇଟା 6ଟା ବେଳେ ହେଇଛି, ତାକୁ ସେ 4:20 ଦେଖେଇଛି. How far it has affected the prosecution case? କଣ ହେଇଗଲା ଯଦି 4:20 ଏମିତି ଏଇଟା ଦେଖେଇ ଦେଲା, କଣଟା ମାନେ how you said
it further affects the root of the case.
କହୁନାହାନ୍ତି କଣ କେମିତି how far
The inception is vulnerable. The inception is not clear. The inception is not beyond reasonable doubt. When the inception itself is doubtful, thereafter witnesses were arranged, evidence was created, Giridhari, those statements were not forwarded. The overall, so inception, it hits at the inception of the case.
ନାଇଁ ନାଇଁ IO
Suppose the present affair may not be the affair which was handed over.
no ସେମିତି ଆପଣ ଖାଲି ହାଇପୋଥେଟିକାଲି ଆର୍ଗୁମେଣ୍ଟ ଆଣିବେ ନା, ଏଭିଡେନ୍ସ ନ ଆଣିଲେ କେମିତି ହବ? ସ୍କ୍ରାଇବ ଯିଏ
and safe custody, PW 15 has said that
ଯଦି ଏ ଲୋକଟା ଆଇଓ ଯଦି ମନେ କରନ୍ତୁ ଆପଣ କହନ୍ତୁ ଯଦି ଆଇଓ ୟାକୁ 6:20 ଦେଖେଇଥାନ୍ତା ଏଫଆଇଆର ରେଜିଷ୍ଟର୍ଡ ହେଇଛି ବୋଲି, ତାହେଲେ କଣଟା ପ୍ରସିକ୍ୟୁସନ କେସର ଅସୁବିଧା ହେଇଥାନ୍ତା କହୁନାହାନ୍ତି?
ନାଇଁ ପରେ ହେଇଥିଲେ କିଛି ହେଇନଥାନ୍ତା।
ନାଇଁ ନାଇଁ ପୁରା କହୁଛି ଆପଣଙ୍କୁ କୁହାହେଲା ଯେ ଆଇଓ ଯଦି ଆଇଓ କଣ ପାଇଁ ତାହେଲେ 420 କାହିଁ କଣ ପାଇଁ କରିବ ତାକୁ? ଆମେ ଆସିବା ନା ତାପରେ ନେକ୍ସଟ କ୍ୱେଶ୍ଚିନ୍ କୁ ଆସିବା ଯେ ଆଇଓ ଏଠି 6:20
say some affair was given, station diary entry, it was lying there, not went to the police station or anywhere. Then some different picture comes, another story is drafted.
in
given the same number.
that way the not only the scribe, the informant, everything has to be suggested and something has to be brought out on record that this the FIR is not the first original FIR, it has been suppressed, whatever you have given that has not been, this is subsequently ei type ro no anile case make out no kale khali argument kala hobo ki ଆଉ କଣ କହିବେ କୁହନ୍ତୁ?
Okay, 114 PW 15 relating to that safe custody.
Just a minute. ହଁ କଣ ହେଲା?
PW 15 114 page.
114.
He is the constable who took it from the court, took it from the PS to the court, and after forwarding letter of the learned magistrate, produced it before arrest session.
That exhibits include that you are harping on that acts or what?
No, total.
In general.
Cross-examination part. My statement was not recorded by the IO during investigation. The seized exhibits were at police station. I cannot say under which MR number the seized articles were kept at the police station. I do not recollect the exact time when the command certificate was issued to me. I do not recollect how many packets were brought by me on that day. I cannot say whose signatures were available on those packets. For that reason.
No. Have you put these questions to the IO, the man who has seized it, and the man who has kept it? Because the IIC is the in charge of the Malkhana.
Yes, some suggestion.
କାହିଁକି ନା ଯାହା ବି ରହିବ ତାର ସେ ମାଲଖାନା ରେଜିଷ୍ଟରରେ ଏଣ୍ଟ୍ରି ହେଇଥାଏ ଏଇ ଆଇଟମ ଏଇ ଦିନ ଏଇ ସମୟରେ ରହିଲା, ଗୋଟେ ଏଣ୍ଟ୍ରି ରହିଲା, ଏବଂ ଯେତେବେଳେ ମଧ୍ୟ ସେଠୁ ବାହାରିକିନି କୋର୍ଟକୁ ଯିବ ବା କେମିକାଲ ଏକ୍ସାମିନର ପାଖକୁ ଯିବ ସେଇ ଡେଟ୍ ଆଉ ଟାଇମ ମଧ୍ୟ ପଡିବ ତା ଦେହରେ, ସେଥିରୁ ଜଣା ପଡିବ ଯେ ଏଇଟା ସେଫ୍ କଷ୍ଟଡିରେ ରହିଲା.
None of the seizure witnesses say we have signed on those any of the articles sealed. Even from the spot, the wiring approvals, there is no signature of any of the seizure witnesses.
ସେଇ ଯୋଉଗୁଡାକ ଆପଣ କହୁଛନ୍ତି the seizure procedure ହଉଛି ମନେକର 7ଟା ସିଜ୍ ହେଲା, 7ଟା ଗୋଟେ ପ୍ୟାକେଟ ହିସାବରେ ରଖାଯିବ, ସିଲ୍ କରାଯିବ ଏବଂ obviously ତା ଦେହରେ ଯୋଉ ସିଜର ୱିଟନେସ୍ ତାଙ୍କ ସିଗ୍ନେଚର ମଧ୍ୟ ରହିବା ଉଚିତ ହେଲା, ଏବଂ ସେଇ କଣ୍ଡିସନରେ ଆସିକିନି ମାଲଖାନାରେ ଯଦି ଆପଣ ତାକୁ ରଖିଲେ ସେମ୍ ଡେ ନ ପଠେଇକିନି ମାଲଖାନା ଏଣ୍ଟ୍ରି ରେଜିଷ୍ଟର ହେଇଥିବ ଏବଂ ଯୋଉ ଦିନ
That
ବାହାରିବ
said witness denied that. I
Hmm.
don't know what is the MR number.
ନା ନା ଏଇ ୱିଟନେସ୍ ଟା କେବଳ ନେଇକି ଯାଇଛି ହି ଇଜ ନଟ୍ ଏ ୱିଟନେସ୍ ଟୁ ଦି ଦ୍ୟାଟ୍
Where it was
seizure.
kept.
Yes, he has
My lords,
carried this.
He has just carried it
at this
from
stage, my lords,
from the police
actually,
station
my
to
lords,
the
subject to correction, burden lies on them. In spite of our challenge,
Hmm.
it is burden of the prosecution which never shifts.
but again, Mr. Let us say that there are some
But
discrepancies
challenge
in
it has
the
been challenged.
seizure. Let us say to that extent, the seizure, preservation, एगुड़ाकरे ये इची. But it is not a case of NDPS. It's a case of how do you, unless you are able to demolish the evidence of the eyewitnesses, mere discrepancy in the evidence of the seizure or something, can it be the court can just throw away the evidence of the eyewitnesses and there because there is some lacunas here and they are in the investigation, some seizure
No,
witnesses
what
are
has
not.
been sent for chemical examination,
Hmm.
like the weapon was not produced when the eyewitnesses were examined. The
Let us say, Mr. We are going to the extent, we'll totally discard the CE report. Then how do you meet it?
still, then oral evidence is enough.
ସେଇଆ ତ କଥା
No,
ହଉଛି.
I'm not on the result.
ନା ନା
Whatever
ଆପଣ ଯାହା
little bit
ଆମେ
is there,
ଟୋଟାଲ କାଟି
I
ଦଉଛୁ
will just point it to the
କାରଣ
court.
ଲିଙ୍କ
That's all.
ଭିତରେ ଆସୁଛି ସେଇ ହ୍ୟୁମାନ ବ୍ଲଡ ଟା ଆସୁଛି ଯୋଉ ଭାର୍ସାଟାରେ ଆସୁଛି
Right.
ଆଉ କେତେ ଗୁଡାକ
Group
ଇଏ
ta
ଆସୁଛି
nahi, but human blood.
ହଁ
And seizure witnesses are interested. They are not natural. That is all. That is all, because
yes sir. So but since Patkia is said that he is likely to finish it, if it is not there then it will continue on 24. But as we said yesterday that we will pass an order regarding
we
collection
will
of
get
this
that.
for that because that is the decision of the Honorable Supreme Court. So we may give you some time,
Yes, sir.
right, for that purpose. So in the meantime, you finish your argument.
Yes, sir.
Simultaneously, we pass that order today itself. That you collect all those information. That is this health condition, that
Yes,
conduct
I
in
have
the.
not got the order.
You have got the order? No, how can you got it?
Aji
We have not passed the
Aji
order.
habo.
ଆଜି ହବ ଆମେ
Hopefully.
ଆଜି
Sir.
ହବ ଆମେ ଆପଣଙ୍କୁ
Yes,
ଦିଆଯିବ
free
କପି
copy ଦେଲେ
free copy
circulate କରିବେ
ହଁ
secretary senior
ହଁ ହଁ
Probably କାଲି order ଟା pass ହେଇଯାଇଛି।
ନାଇଁ 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 we'll pass the order today. So 24th ରେ ଆପଣ ଆଜି ଚେଷ୍ଟା କରନ୍ତୁ ସାରିଦେବା ପାଇଁ ଯଦି ନ ସରିବ 24 ରେ ରହିବ so you begin your hour.
May I please, your lordship?
Yes, Mr.
Yes, what my learned friend was submitting regarding the FIR
Hmm.
that both Navin Devuri and Navin Devuri Hemanand Devuri Tangier Hanidele. And that contradicts the statement of VW1, VW3, and VW4. That was the submission.
Yes.
So my point is, my humble submission to the lordship is, so in what way the FIR is to be looked? Plus, FIR is not an encyclopedia
Hmm.
of the entire case, and to that extent, just I was relying upon the judgment.
Yeah.
2019 volume 12 SCC.
Sorry.
2019 volume 12 SCC.
Yeah.
326.
Yes. What is the name?
State of MP versus Chakilal.
State of MP versus
Chakilal.
Chakilal. Which paragraph deals with it?
19 plus paragraph 19.
What it says? No, it's all right. Sir. No problem.
You can proceed. You read, you can.
Yes. Paragraph 19.
Because I'm reading from the last line, last 4 lines of paragraph 18.
Achha,
Then I'm going
last
to type.
4 lines of- Okay.
The London last 4 lines.
Yes, yes.
The London counsel for the respondent accused submitted that Shokila jumping on the abdomen of the child Rinku was not mentioned in Dehati Nalisi, Exhibit P1 and FIR. And this material omission suggests that Kesarbai, PW1, exaggerated her version about throwing of child Rinku on the floor and jumping on his abdominal region. Then was relevant paragraph 19. FR is not an encyclopedia which is expected to contain all the minute details of the prosecution case. It may be sufficient if the broad effects of the prosecution case are stated in the FIR. In this case, firing by accused Shokilal at child Rinku was stated in the FIR, and the omission of minute detail that Shokilal jumped on the abdomen of child Rinku cannot be regarded as fatal to the prosecution case. As discussed earlier, the effect of occurrence on the mind of an old woman like Kesarbai, P.1, cannot be measured in yardstick. Being grief-stricken because of the death of her 4 kith and kin, it may not have occurred to Kesarbai, P.1, to narrate all the minute details of the occurrence. The non-mention of accused Shokilal throwing the child Rinku on the ground and jumping on his abdomen, due to which the intestine came out, cannot be regarded as fatal to the prosecution case. Plus, then I'm again reading 20, 21, 22. The High Court acquitted the accused merely on the ground that the evidence of Kesarbai is fraught with contradictions. Kesarbai P.1 was a rustic villager and also aged. After seeing her own daughter and daughter-in-law and grandson being put to death, she must have been under tremendous shock. Kesarbai P.1 was deposing in the court after some time. Naturally, there are bound to be variations from her earlier version. The trial court, which had the opportunity to observe the demeanor of the witnesses, found that the evidence of P.6 is credible and trustworthy. While so, the High Court ought not to have recorded a finding raising doubts about the credibility of Kesarbai P.1. Then P.21, the trial court had the opportunity of seeing and observing the demeanor of the witnesses, and the views of the trial court as to the credibility of the witnesses is entitled to great weight. Unless the appreciation of evidence by the trial court was vitiated by serious error, the findings recorded by the trial court ought not to have been interfered with by the High Court. 22 plus. In our considered view, the High Court aid in doubting the testimony of Kesarbai P.1. It would be unreasonable to contend that merely because Kesarbai P.1 is related to the deceased and that there were contradictions in her evidence has to be discarded. Discrepancies which do not shake the credibility of the witness and the basic version of the prosecution case are to be discarded. If the evidence of the witnesses as a whole contains the ring of truth, the evidence cannot be doubted. Your logic just a few minutes back pointed out, it's a ring of truth. So from the evidence of PW1, PW3 and PW4 and so also PW5, there is a ring of truth regarding the complicity of Nobin Deori. Then we shall come to the Hemanand Deori. First Nobin Deori, there is no doubt PW5 is very clear in the evidence. Only thing what my learned friend was arguing on that point, because Nobin Deori came by a motorcycle
By walk and
3 kilometers, passing through 3 kilometers. He should have reached earlier.
The PW5 came through motorcycle.
Yes, came through motorcycle.
Nabin
Because-
came through this road or shortcut.
Nabin, the PW5 came by motorcycle. After seeing the incident, that Nabin has been assaulted. Nabin assaulted that Giridhari. After watching that, he came by motorcycle. So my friend's contention was that he should have reached much earlier than Nabin came to the second spot of occurrence. But by the time PW5 had arrived, occurrence had already taken place.
Yes.
And accused persons were not there. So there was a contention raised by my friend because he came and informed the PW1, the informant, that Giridhari has been assaulted by Nobin.
ସେ ଆଉ ଗୋଟେ ଜିନିଷ ସେଠି ଆଡ୍ କରୁଛନ୍ତି ଯେ ଯଦି PW5 ପିଲାଟା ସେ ଆସିକିନି ପହଞ୍ଚିଲା ଏବଂ ସେ ଗୋଟେ ଆଇ ୱିଟନେସ୍
Yes.
କହିଲା ଅନ୍ୟମାନେ ଅବଶ୍ୟ ସପୋର୍ଟ କରୁନାହାନ୍ତି ତାହେଲେ ତାପରେ ଏଫଆଇଆର ଡ୍ରାଫଟିଂ ହେଇଛି ତାହେଲେ ଏଫଆଇଆର ଆଟଲିଷ୍ଟ ଲେଖା ହବା କଥା ଖାଲି ଲେଖା ହେଲା କଣ ସେଇ ଯୋଉ ଡିସିଜ୍ଡ ର information
Yes.
টা কেমিতি পাইলে utterance
Yes.
পাইলে
That I'm
এইটা ହୁଏତ ଲେଖା ହେଇ ପାରିଥାନ୍ତା ଯେ ଏଇ ଯୋଉ ଇଏ ତାକୁ ମାରିଛି ବୋଲି ଇଏ ଆସିକିନି ମଧ୍ୟ କହିଲା
no, that is covered by this judgment. That is already covered by this judgment. But still, I am answering to that. What has happened? By the time P5 arrived at that spot of occurrence, by that time already the occurrence is over.
ସେ ଏଇ occurrence ଟା over
Over.
you are right
And the accused Nobin has already given a declaration that I have killed Giridhari. So it was very well within the knowledge of the P1, P2, not P2, P3, and P4, and also other persons that Giridhari has been murdered. Only thing is they have to go to that place of occurrence to ensure that, yes, to see the dead body. Because there is a, so by the time, at the time of that incident, second incident, so the, I mean, PW1, PW3 and 4, your state of mind of those persons will also be kindly appreciate in what state of mind they must be there. And at that point of time, when they already knew that Girdhari is already dead and he has been killed by the.
so you mean to say
So PW5's intimation doesn't carry any importance for them at that point of time.
in view of the state of mind of those related family members
Yes.
after seeing that two persons were murdered
Yes.
in their presence and after knowing that one person is lying dead
Yes.
it would not be they would not be stable
Yes.
so as to mention all the
Yes.
details
My lord.
in
Yeah.
the FIR.
Obliged.
That's
Okay.
Please continue.
Plus now the FIR vis-a-vis the statements of eyewitness to the second at the second place of occurrence. That is PW1, PW3, and
Before
PW4.
going to the statement, in between something else is there that about he argued about that inquest report.
Plus, in inquest
Okay,
later
you will
on,
come after. All right.
I am on the FIR now.
All right.
So FIR vis-a-vis the statement of PW1,
Hmm.
PW3, and PW4.
Hmm.
That at least plus that suggests that both the accused persons were present at the spot of occurrence, second spot of occurrence.
Hmm.
The presence cannot be doubted. Because in the
Yes.
FIR, their presence is there. It cannot be said that in the FIR, in minute details, as already in the judgment that will come to my head, that is, they have stated that Nobin Dehuri and Nobin Dehuri for Heman Dehuri Tanger handle. What best he can tell to someone else when he must be in a very disturbed state of mind. And that has been put in writing by another person who has been examined as PW8. Now, some aspects PW1, your lordship will get the statement. I am taking your lordship that. At page 66.
Page 66 of the
66.
past paper book.
Yes, past paper.
PW1's evidence.
Yes. I am reading from the very beginning.
এই ডিসিশন নাও কিছু দেখিବାକୁ নাই তো
Okay.
ঠিক আছে Yes.
I am the informant in this case. I have lodged report against the accused person, namely Hemanand Dehuri and Nabin Dehuri, who are standing in the dock. This is Girdhari was my elder brother-in-law. This is Piruvati was my mother, and this is Sabitri Sahu was my elder sister. The alleged incident was happened on 21/10/2020. Since my parents had no son, my deceased brother-in-law was residing in my father's house as illegitimate son-in-law. On the previous day of the alleged occurrence, I had gone to village Laporda to my father's house. On the occurrence day, around 2:30 p.m., my elder brother-in-law went to the paddy field. Here, I am again reading. On the occurrence day, at around 2:30 p.m., my elder brother-in-law went to the paddy field. After 15 to 20 minutes thereof, my sister and mother left the house to go to paddy field. Here, my learned friend has submitted that together they had gone. Of course, that was not given any importance by my lord on Das. Because what they have stated, by the time the informant came out of her house, all the three left for their culpable lands. They came out. They have left the house. By the time she came out, only specific time, 15 to 20 minutes after he has stated here, and also in her statement recorded under section 161 CRPC, which has been confronted to the IO.
ସିଏ ଯୋଉ ଏଫଆଇଆର ରେ କହିଲା ଯେ 21/10/2020 ତାପରେ ଗୋଟେ କଣ ଲେଖା ହେଇଛି
ଦିବା 2 ଘଣ୍ଟା
ବୁଧବାର ଦିନ
3 ଘଣ୍ଟା
3 ଘଣ୍ଟା ସେଟା ଆକ୍ଚୁଆଲି 3 ଘଣ୍ଟା ସମୟରେ ମୋର ଭେଣୀ
ସେ ଗିରିଧାରୀ
ଗିରିଧାରୀ ତାପରେ ମା
ତୀରବତୀ
ହଉଛି ପୀରବତୀ ଆଉ
ସାବିତ୍ରୀ
ନାନୀ ହଉଛି ସାବିତ୍ରୀ
ଧାନ କାଟିବା ଜମି
ଧାନ
ଗଲେ
କଟିବା ପାଇଁ ଜମି
ଏତିକି କଥା ସେ କହିଛି
ସିଏ କହୁଛନ୍ତି ୟା ମାନେ ହଉଛି ସେମାନେ ଏକା ସାଙ୍ଗରେ
ଗଲେ
ସେଇଟା ସିଏ ଅବଶ୍ୟ କହିନି କି ଧାନ କାଟିବାକୁ ଗଲେ ଯୋଉଟାକୁ କିନ୍ତୁ ଇଏ PW1 ପରେ କ୍ଲାରିଫାଏ କରୁଛି ଏଭିଡେନ୍ସ ରେ ସେ ହଁ ଯେ ଇଏ ପ୍ରଥମେ ଗଲା ଯିଏ ତା ଭେଣେଇ ଯିଏ ତାପରେ ମାନେ ମା ଆଉ ଭଉଣୀ ପରେ ଗଲେ ସେଇଆ ତ
so by the time she came out she saw that her mother was pumping the tubewell and my sister was pouring in a bottle. Yes, no, sir. At a list, I found my mother was pumping the tubewell and my sister was pouring water in a bottle. At that time, both the accused persons came. Here was again the appearance of both the accused persons together. And accused Nabin suddenly dealt a blow by means of an axe on the neck of my mother. Seeing this, my sister threw the bottle and went to rescue my mother, but accused Hemanand restrained my sister by dragging her hair. I'm just taking a pause. Now I'm taking a lordship to the evidence of the IO, PW20, page 134. Paragraph 27. It is not a fact that witness, namely Manikya Prusset, PW1, has not stated before me. That means she has stated in her statement that she being called by her brother-in-law one day prior to the incident had been to village Lapoda, and that at about 2:30 p.m. his elder brother-in-law went to the paddy field, and after 15 to 20 minutes her mother and elder sister left the house to the paddy field, and that after their departure she along with her nephew and niece came outside a veranda, and that at a little distance from their house the village Jagannath temple situates, and that while the accused Nabin assaulted her mother by means of a tangia, seeing this her sister threw a bottle, and that while her sister went to rescue her mother, the accused restrained him by dragging her hair.
ଏଇ ଜିନିଷଟା ଆମେ ପ୍ରକୃତରେ କହିନି ଏଟା ତା ଭିତରେ ମିଶିଗଲା ଯୋଉ accused restrained him by dragging her hair and accused Nabin repeatedly dealt 3 to blows on the neck of the father ଏଟା ଆମେ ଦେଖିଲୁ ପରା 161 ରେ ପ୍ରକୃତରେ ଏଇଟା କହିନି ମାନେ ଯୋଉ ଇଏ ଖାଲି କହିଛି ସେ ଯୋଉ ଛେକିଦେଲା ଛେକିଦେଲା
So substantially she has corroborated her interception.
ଅନ୍ୟ ଗୁଡାକ
ସବୁ
ସେ
So regarding restraint part also it is there. It has been restrained.
ଛେକିଦେଲା ମାନେ ତ ଆମେ ଦେଖିଲୁ ବ୍ଲକିଂ ସୁବିଧା
ସବୁ ଅଛି
so you can say ଯଦିଓ 161 ରେ ସେ କହିଥିଲା ମାନେ ଅଟକେଇଲା ବା ତାକୁ କିନ୍ତୁ କୋଉ ୱେରେ ଅଟକେଇଲା ସେଇଟା ସେଥିରେ କହିନି ଏଠି କ୍ଲାରିଫାଇ କରିଛି ଯେ by way of so that may not amount to contradiction.
Yes.
Okay.
I don't like deep localized. So, but this witness is this much regarding restraint caused by the second accused Hemanand.
And this line also has not stated. ये जो ଦି ଜଣ ଯାକ ତାପରେ ଟାଙ୍ଗିଆରେ ମାରିଲେ ବିଭିନ୍ନ ପାର୍ଟ ଅଫ ଦି ବଡି
Yes.
ଯୋଉଟା କି କଣ୍ଟ୍ରାଡିକ୍ସନ ଏଇଟାକୁ ଆସିଛି ସେଇଟା ଇନଫ୍ୟାକ୍ଟ ନାହିଁ ମାନେ ଦି ଜଣ ଯାକ ଟାଙ୍ଗିଆରେ ମାରିଲେ
Man,
ତା ପର ଲାଇନ ଟା ଦେଖୁନାହାନ୍ତି ଏଇ ଯୋଉ 3 to 4 blows
yes, both the accused person dealt several blows on
ହଁ
different parts of body of the deceased
ସେଇ
by means of
ଜିନିଷଟା ନାହିଁ
Tangia.
ସେଇଟା ୟା ପାଇଁ ଅଛି କେବଳ ନବୀନ ପାଇଁ ଅଛି
ଅଛି।
ଆ
ନାହିଁ।
ପାଇଁ କେବଳ ଓଭରଟାକ୍ଟ ହଉଛି ସେ ଚୁଟିକୁ ଧରିଲା ଯେତେବେଳେ ଯାଉଥିଲା ତା ମା ପାଖକୁ ଅଟକେଇକି ରଖିଲା
Yes, yes. And that loss was already marked that paragraph 8. While Nabin was assaulting, in cross examination was stated, while Nabin was assaulting, accused Hemanand was holding my sister. So now I am taking a lordship to the evidence of relevant part of PW 4, page 77.
ଗୋଟେ ଗୋଟେ ଯୋଉଟେ ଡିସିସନ ଅଛି ଏଇ ଟାଇପ ର ଏଇ ଯୋଉ ଇଏରେ ଯେ ଇଟ୍ସ ଅଲ୍ ରାଇଟ୍ ଯେ ସିଏ ରିଷ୍ଟ୍ରେଣ୍ଟ କରିଦେଲା ରିଷ୍ଟ୍ରେଣ୍ଟ କରିନଥିଲେ ହୁଏତ ସିଏ ପଳେଇଥାନ୍ତା ରିଷ୍ଟ୍ରେଣ୍ଟ କରିଦେଲା ବୋଲି ଇଏ ତାକୁ ମାରିଦେଲା କିନ୍ତୁ ରିପିଟେଡ ବ୍ଲୋ ଯୋଉ ହେଇଛି ଯଦି ଏଭିଡେନ୍ସ ନଥିବ ଯେ ଇ ମାନେ କଣ୍ଟିନ୍ୟୁ ଟୁ ରିଷ୍ଟ୍ରେନ୍ ହିମ୍ ଇନ୍ ସ୍ପାଇଟ୍ ଅଫ ଦି ଫାଷ୍ଟ assault ତାହେଲେ କୁହାଯିବନି ଯେ କମନ ଇଣ୍ଟେନସନ ସେୟାର କଲା ବୋଲି ସେଇଟା ତାକୁ ଡିଷ୍ଟିଂଗୁଇଶ କରିଛନ୍ତି ଇନ୍ ଦିସ୍ ୱେ ସିଏ ହୁଏତ ଅଟକେଇଥିବ ଗୋଟେ ପର୍ପସ ପାଇଁ ତା ଭିତରେ କିଏ ଗୋଟେ ବ୍ଲୋ ଦେଇ ଦେଇଥିବ କିନ୍ତୁ ଯୋଉଠି ରିପିଟେଡ ବ୍ଲୋଜ ହେଇଥିବ ସେ କହୁଛନ୍ତି ଯେ ୟୁ ଆର୍ ଟୁ ଏଡ୍ୟୁସ୍ ଫର୍ଦର ଏଭିଡେନ୍ସ that he continued to restrain her and ସେ ମାରି ଚାଲିଲା ଏ ଯୋଉ continued word very important because of କାରଣ ସିଏ ତାକୁ ହୁଏତ ପ୍ରଥମରୁ ଅଟକଉଥିବ କିନ୍ତୁ କମନ ଇଣ୍ଟେନସନ ଯୋଉ ସେୟାର କରିବାକୁ ଏଠି ଆପଣ ତିନିଟା କେତେ ଗୁଡାଏ ଜିନିଷ ଆସୁଛି ଦେଖନ୍ତୁ they came together they left together one man assaulted first to the mother he also assaulted to the daughter okay Sabitri na kଣ this man's role is that he restrained ଏତିକି ହଉଛି ତା ରୋଲ ତ ସାଙ୍ଗରେ ହେଇକି ମେନ୍ ଆକ୍ୟୁଜ ସାଙ୍ଗରେ ଆସିଲା ସାଙ୍ଗରେ ଗଲା ଘଟଣା ଜାଗାରେ ଥ୍ରୁ ଆଉଟ୍ ପ୍ରେଜେଣ୍ଟ ରହିଥିଲା ଏବଂ ତା ସହିତ ଗୋଟେ ଡିସିଜ ଯେତେବେଳେ ଆର ଡିସିଜ କୁ ମାଡ଼ ଖାଉଛି ଯେତେବେଳେ ରେସ୍କ୍ୟୁ କରାଯାଉଥିଲା ତାର ଚୁଟିକି ଧରିକି ଅଟକେଇଲା ସୋ ଏଇଥିରୁ ଆମେ କମନ ଇଣ୍ଟେନସନ ରହିଛି କି ନାହିଁ particularly ହଁ ଏଠି ଆଉ ଗୋଟେ କଥା ଯୋଉଟା କାଲି ପଏଣ୍ଟ ଆଉଟ କରୁଥିଲୁ ଆମେ ଯେ ସବୁ ଗୁଡାକ assault front side ରେ
and also neck range.
ତେଣୁ ହୁଏତ ମାନେ ଯଦି ତାକୁ ଛଡା ହେଇଯାଇଥାନ୍ତା ତାହେଲେ ଫାଷ୍ଟ assault ପରେ ସିଏ ହୁଏତ ବୁଲି ଯାଇଥାନ୍ତା କି କଣ ହେଇଥାନ୍ତା ତାହେଲେ ମାଡ ଗୁଡାକ ପଛପଟେ ବା ଅନ୍ୟ ଜାଗାରେ ହବାର ସମ୍ଭାବନା ରହିଥାନ୍ତା କିନ୍ତୁ that shows that ସେ ନେକ୍ ଏଇଟାକୁ ଧରିକିନି ରଖିଛି ଯୋଉଟା କି ଫ୍ୟାସିଲିଟେଟ କଲା ସବୁ ତକ ଚାରିଟା ଯାକ ମାଡ ସାମ୍ନାରେ ଆଣିବା ପାଇଁ ସେଇଟା ଗୋଟେ circumstance ଆସିବ if you analyze in this way you can get many points
and I'm qualifying my argument that I have advanced yesterday that is regarding the presence of the accused and the role he has played while his father was going and giving blows that part. And he plus I am even placing placing a proposition for lordship that may kindly be acknowledged that is plus if you are standing there definitely you are out of danger giving the son the aggression principal aggression Navin is not going to assault you and you are the person who can restrain Navin from assaulting either the two either of the two accused two deceased persons you are the person.
So let us say common intention ପାଇଁ ଆପଣଙ୍କର submission ଆମେ note କରୁଛୁ coming together living together presence throughout ହେଲା then not trying to
restrain Navin
restrain Naveen, then holding
Yes. Savitri.
tuft of hair of Savitri, which facilitated Naveen to give 4 blows on front side.
Yes.
These are your
Yes.
arguments.
Another plus the passive sharing of common intentions. Passive is in the active side. Passively, what he was doing, like the presence of the sun, he was giving an impression. Suppose plus other person, other co-believers, if will come to the spot to rescue or to cause some injury to the father, then son is there. So by his presence, passively, he has helped the accused number one, Naveen, to go on assaulting to commit the crime. So the active participation, active restraint, and passive restraint. So he has not even done that. If you are law-abiding citizen, if you are so innocent, you should have done at that particular point of time when your father was going on assaulting 2 ladies, one after the other, mother and daughter. You have not restrained, nor you have not shown any such kind of behavior, so that other person to come up to rescue those 2 innocent ladies, innocent women who are the victims.
ନାଇଁ ଅନ୍ୟ କିଏ ରେସ୍କ୍ୟୁ କରି ଆସିଥିଲା ସିଏ ତାକୁ ପ୍ରୋଭିଡ୍ କଲା ଏଥର ତ ନାହିଁ ଏଇଟା ସେଇ ଯୋଉ ୱାନ୍ ଅଫ୍ ଦି ଡିସିଜ୍ଡ କୁ ସିଏ ରିଷ୍ଟ୍ରେନ୍
That is the reason I use the word passive.
It's like Miller's in a Prevention of Corruption Act case, the son becomes a witness against the father. In a Prevention of Corruption Act case, it's like the son says, my father is corrupt, I should stand up for the prosecution.
It's a different analogy is not
Here, the act of mind.
ହଁ ଆପଣଙ୍କର ସେ କହୁଛନ୍ତି କମନ ଇଣ୍ଟେନସନ ଟାକୁ କେବଳ ଯେ ଆକ୍ଟିଭ ପାର୍ଟିସିପେସନ ରୁ କରାଯିବ
prevented his father from committing a wrong.
ସେଇ
He
ମାନେ
is not doing so.
ସେଇ ଲାଇଟ ରେ ମଧ୍ୟ ଡିସିସନ ଅଛି ସେ ଯୋଉଟା ଆର୍ଗୁମେଣ୍ଟ କହୁଛନ୍ତି ସେ ଲାଇଟ ରେ ଡିସିସନ ଅଛି କାରଣ କମନ ଇଣ୍ଟେନସନ ଟାକୁ କେବଳ ଆକ୍ଟିଭ ପାର୍ଟିସିପେସନ ରୁ ଜଣାଯିବନି ବିଭିନ୍ନ ଆଙ୍ଗେଲ ରେ ମଧ୍ୟ କମନ ଇଣ୍ଟେନସନ ଓମିଶନ also in some cases that will also କାରଣ ଯେମିତି ଆପଣଙ୍କର ଆବେଟମେଣ୍ଟ ରେ ଆପଣ ଆବେଟମେଣ୍ଟ ରେ ଓମିଶନ ୱାର୍ଡ ଟା ୟୁଜ ହେଇଛି ମାନେ just let us
by doing any commission or omission
that word has been karan
omission to do certain things
right
also comes within that ambit.
Okay, you proceed.
And PW, in PW, your lordship will come to, your lordship has seen it, just I am minding your lordship. Page 76, PW3 has stated, they are so truthful, even they have not, they have, I mean, both the children, they have stated that he was not armed, he has not given any blow.
17 ବର୍ଷ ପିଲା ସେକେଣ୍ଡ ଇୟର ପ୍ଲସ୍ ଟୁ ଫାର୍ଷ୍ଟ ଇୟର ପଢୁଛି ତେଣୁ
please, but the witness voluntarily states that he was assisting his father. That part has not been traversed, and no defense witness has been laid here in this case. He was assisting his father.
Which paragraph of
that paragraph
PW?
8 plus
8
70 is paragraph 8. He is saying no assault was given by the accused Hemanand. That shows that he is so truthful. But the witness voluntarily states that he was assisting his father. Accused Hemanand was not armed with any weapon. That shows also he is quite truthful. Then you can come to
କୌଣସି ହାତ ହତିଆର ମାନେ ହତିଆର ଧରି ନଥିଲା କୌଣସି ପ୍ରକାର ସିଏ ନିଜେ ମଧ୍ୟ ଡାଇରେକ୍ଟ ଆସଲ୍ଟ କରିନି କିନ୍ତୁ ବାପାକୁ ସାହାଯ୍ୟ କରୁଥିଲା ଏଇଆ ତ ଆଉ କଣ ହଁ
and again page 77 you also can come to paragraph I mean witness period 4. Last 2 lines, thereafter he dealt 3 blows on her neck. My maternal grandmother fell down on the ground. Thereafter he dealt 3 blows on her neck. While my mother went to rescue my maternal grandmother, accused Hemanand alias Mantu restrained my mother by dragging her hair and accused Naveen assaulted by means of pudiya. Then last line I have pointed out yesterday. It is not a fact that I have not stated for the police that accused want to track the hair of my mother. To that, she has clarified the entire aspect by at paragraph 11. Accused Hemanand was not armed with any weapon. It is a fact that no assault was given by accused Hemanand. He had only restrained my mother.
So what you say that even if
So-
he has restrained,
Yes.
because of these other things which you
Yes.
just said, then also it can be said that he has shared
Shared the common intention
with the
father.
man accused by not being inside.
But the father, after killing Giridhari in the field, he came, and somewhere this person has joined, because either he has not been seen by people 5, or he has concealed himself somewhere.
Possibility is there.
Possibility is there. These are the possibilities. Or somewhere on the way, that 700 meters, he joined with his father. So when the father was coming, killing one person, he must be in a very violent, because so many blows have been given by that person to Giridhari. So he must have coming with a violent, very violent state of mind, which must have understood by this Hemanand. But he joined him. He came to the second spot of occurrence, and there was a cumulative reading of the entire evidence, PW1, PW3, and PW4, so, along with coupled with the FIR. It shows that this person very well present and was assisting his father. What PW3 is saying, it is correct, and he has and not restrained. He had only restrained my mother by restraining his mother, but not restraining his father. That itself suggests that he shared the common intention with his father, because his father is killing 3 persons in a row, I can say. Because one has been killed in the field, then he came to the second spot. There, within a few seconds, he killed 2 ladies, and all belong to one family. So it cannot be said at any stretch of imagination that he has not shared the common intention with his father.
ସେଠୁ ଆସିଲା ପରେ ଘଟଣାଟା ତ ହେଇଛି immediately ହବ 800 ମିଟର ନା
700 meter.
700.
I have still one doubt.
Yes.
In the FIR,
Yes.
it speaks about the place where the dead body was lying is just 200 meters. See, read it. ପରେ ଗାଁର ଲୋକେ ଖୋଜାଖୋଜି କରିବାରୁ ବନ୍ଧର ଉପର ପଟ ବାଡ଼ ପ୍ରାୟ 200 ମିଟର ଦୂରର ଚଲା ବାଟରେ ଜମି ଭିତରେ ଗିର୍ଧାରୀ ସାଙ୍କୁ ହାଣି ଯାଇଥିବାର ଦେଖିଲେ.
These are all
So it
called
is
rustic
only
villages.
200 meters.
Huh.
It is not 800 meters.
That is below
Maybe it is the entire
spot map
spot map से 800 देखिए पूराଟାକୁ.
7 ନା ଗୋଟେ ଆଉ ଗୋଟେ ବାଟ ଅଛି.
ଗୋଟେ ବାଟ ଅଛି ସେଟା ଆଉ ଥରେ
Other
ଦେଖିବା
than that,
Yes.
ଆଉ ଥରେ
ଆଉ ବାଟ.
ସେଇ ଯୋଉ
because
ଦିଟା ହିଁ ବାଟ,
ଦିଟା
ଗୋଟେ
ବାଟ।
ଚିପେବୁଲ, ଗୋଟେ ଚାଲିବା
ଗୋଟେ ଚାଲିବା ବାଟ
ସେଟା
ଗୋଟେ
minor contradiction ଟିକେ ଟିକେ କୋଉଠି ଅଛି.
ସିଏ ଆସିଛି ସେ ଯୋଉ ବିଲ ବଟ ଦେଇକି
ବିଲ ବାଟ.
ବାଟେ।
Yes.
ଇଏ ଆସିଲା ବାଇକ ରେ,
କେତେ
ତାର
ନମ୍ବର ପେଜ ସେ ସ୍ପଟ ମ୍ୟାପ ଟା ମିଷ୍ଟର
171
171
271.
sorry
271.
271
Approximately 800 meters.
just ଏଇଟା ହେଲା 40 ଫୁଟ ନା ତାପରେ ଏଠୁ ଏଇ ଯୋଉ ବାଟଟା ଏଇଠି ପଡିଛି
Eight plus
ନାଇଁ ନାଇଁ ଏଠୁ ସିଧା ଗୋଟେ ବାଟ ଅଛି ଏଠିକି ଯୋଉଟା କି ଏଥିରେ ଦେଖେଇଛି
କୋଉ ପାଖରୁ ସେ ସାଇଡ୍ ରାସ୍ତାଟା ଅଛି.
ବାଟଟା ଗୋଟେ ଦେଖେଇଛି ଗୋଟେ ହଉଛି ଚଲା ବାଟ ଆଉ ଗୋଟେ ବୁଲିକିନା ଆସିବ ପରା
ସେଇଟା
ଆଉ
ମେନ୍
ବୁଲିକି
ରୋଡ,
ଆସିବ, ସେଟା
ସେଇଟା
main
ମେନ୍
road.
ରୋଡ ଟା, ଏଇଟା
ଏଇ-
ଚାଲିବା ଏଇଟା
ସେ ଲାଗିଛି approximately 3 kilometers.
3 କିଲୋମିଟର
ସେଇଟା ଜିପେବୁଲ।
that is 3 kilometers.
3 କିଲୋମିଟର ସେଇଟା ଯୋଉ
ଏଇଟା।
5
ସେଟା
ନମ୍ବର ସାକ୍ଷୀ ଯୋଉଟା
ତାର
ଆସିଛି
2 ହ୍ୱିଲର ଥିଲା, ସେ 2 ହ୍ୱିଲର
ସିଏ ଏପଟରୁ
ତାର
ଆସିଲା
2 ହ୍ୱିଲର ଥୋଇକି ସେ
ଇଏ ଯାଇଛି ଏଠୁ ସିଧା ଷ୍ଟ୍ରେଟ ବିଲ ଗୋଟେ ପଶିକିନି ଏଠିକି ଆସିଛି
but by then PW5 says he was there.
800
First the
800 ମିଟର୍ସ
800 meters that
ସେ ମଝିରେ ସେ ଯୋଉ ରାସ୍ତା ମଝିରେ ଗୋଟେ ଲେଖେଇଛନ୍ତି କଣ, ସେ ଯୋଉ ରାସ୍ତାଟା ଏମିତି ବୁଲି ବୁଲି ଆସୁଛି ପାଦ ଚଲା ରାସ୍ତା,
no, no,
ତା ମଝିରେ ଲେଖିଛନ୍ତି 800, ସେ ମଝିରେ ଗୋଟେ ଲେଖା ହେଇଛି।
approximately
800 meters. ତାପରେ footpath road. ତାପରେ
ଏଇ ରୋଡରେ ସିଏ ଯାଇଛି ଆସିଛି ଇଏ ଯାଇଛି ଏପଟେ ବୁଲିକି
but PW
ଏଇଗୁଡାକ
15
ସିଏ କହୁଛନ୍ତି ସେ 200 ମିଟର
that will
PW 15 କହୁଛି 2 ଜଣ ଜାଗା କ୍ରସ କଲେ, ଆଗ डिसीज क्रॉस कला
ସେମାନେ ଡେଲି ଯାଇ ଯାଇ ତାକୁ ଦେଖୁଥିବେ, ତାଙ୍କୁ ଗୋଟେ ସର୍ଟ ଲାଗିବ।
ହଁ
ଇଏ ଆକ୍ଚୁଆଲ ନେଲା ବେଳକୁ ସେ 800।
ହଁ ପାঁଚଟା ଏଇଟା yes
Plus now coming to the inquest report.
inquest report ରେ ଏକ ନମ୍ବର ନା ଫାଷ୍ଟ ପେପର
सेकंड
inquest report
252. 252 starting.
हाँ 252 ये कॉलम नंबर 9 ऊपर से
Yes,
आर्गुमेंट
boss. That was. I'm answering that. Then signed by Uday Chandra Pushet is a hearsay evidence. For a moment, may I like your lordship's attention to that statement of PW2?
no उदय इज PW2 right
Two.
से PW2 ର ସେ ଲେଖାଟା ହଉଛି ସେ ଏଇଟା ଆଜି ଟାପିଏ ସେଇଟା ବୋଧେ ନିଜ ହାତରେ ସେ ଲେଖିଛି
Yes.
ମୋ
ଲେଖିଛି।
ଶାଶୁମା ପୀରବତୀଙ୍କୁ
Yes.
ମୋ ଶାଶୁମା ସେ ଲେଖୁଛି ମୋ ଶାଶୁମା ପୀରବତୀଙ୍କୁ ନହେଲେ କାରଣ ପୋଲିସ ଲେଖିଥିଲେ ଲେଖା ହେଇଥାନ୍ତା ସେ ୱିଟନେସ କହିଲା ଯେ ତା ଶାଶୁମା ଅମକ ସମୟ ସେ ଯୋଉ ୱାର୍ଡିଂ ଟା ୟୁଜ କରୁଛି ମୋ ଶାଶୁମା ପୀରବତୀଙ୍କୁ ନବୀନ ଦେଉରୀ ଓ ତା ପୁଅ ହେମାନନ୍ଦ ଦେଉରୀ ଟାଙ୍ଗିଆରେ ବାରମ୍ବାର ଆଘାତ କରି ମାରିଛନ୍ତି ଉଦୟ ଚନ୍ଦ୍ର ପୁରେଶ
is the husband of the informant.
husband of the informant.
So what he has gathered from the informant, he has stated it. He has written like this.
Yes.
Because he is a hearsay witness. Perhaps I will page 71 of the first paper book. Lost me kindly hold for a moment. I'm taking to the evidence of that particular person. So if that person, that particular evidence doesn't carry any evidential value, so the very portion whatever he has written by learning from or must be from his wife, that same thing will lekha hai FIR re. तो नवीन देवरू तापो हेमंत देवरू टांगेरे बारंबार शक्त आघात मार देछन कारण because both father and son were present there, so दी जण मार देछन
पार्टिसिपेशन माने वो ये ଜାଗାଟା ହଉଛି ଏତିକି ନ ଜାଗା ତା ଦେହରେ ହେଲେ ମୋ ଶାଶୁ ପୀରବତୀ ଆଉ ଆଙ୍କୁ ନବୀନ ଦେଉରୀ ଟାଙ୍ଗିଆରେ ମାରିଲା ସେତେବେଳେ ଅମକ ଗଲା ବେଳେ ପୁଅ ତାକୁ ଅଟକେଇଲା ଏଇଗୁଡାକ ଲେଖିବା ପାଇଁ ସେଠି ଆଉ ପର୍ଟିକୁଲାରଲି ଓପିନିଅନ ଅଫ ୱିଟନେସ କଜ ଅଫ ଡେଥ ରେ ଏଗୁଡାକ ସବୁ ନାଁ ମଧ୍ୟ ବି ଦରକାର ନାହିଁ ଇଏର ଲେଖିବା ପାଇଁ କିନ୍ତୁ ସେଇଟା ଅପେକ୍ଷା ସିଏ ମିଷ୍ଟର ଷଡଙ୍ଗୀଙ୍କର ଆର୍ଗୁମେଣ୍ଟ ହଉଛି ଆଉ ଗୋଟେ ଛୁରୀ ଗୁଡା କୋଉଠି ଗୋଟା ହଁ ସେଇଟା ହଉଛି ସେ ବେଶୀ ହାର୍ଡ କରୁଛନ୍ତି ନେକ୍ସଟ ମାନେ କୋଉଟା 253 ଟା ନା 52
ଲାଗିଲା ତିନିଟା ଅଛି
ମାନେ ଦୁଇଟାରେ ଟାଙ୍ଗିଆ କଥା କହିଲା ତୃତୀୟରେ ଛୁରୀ କଥା
ଏଇଟା ଆଚ୍ଛା 253 ଟାକୁ ଆସନ୍ତୁ ସେ ମୋର ନାନୀ ସାବିତ୍ରୀ ସାହୁଙ୍କୁ ନବୀନ ଦେଉରୀ ତାର ପୁଅ ଆଚ୍ଛା ସ୍ତ୍ରୀ ଲେଖା ହେଇଥିଲା କଟା ହେଲା 3 ଜଣ ଜାଗାରେ 2 ଜଣ ହେଲା ଟାଙ୍ଗିଆରେ ହାଣି ମାରିଦେଲେ ଟାଙ୍ଗିଆରେ ବାରମ୍ବାର ଆଘାତ କରିଦେଲା ପରେ ତାର ମୃତ୍ୟୁ ହେଇଛି
ପ୍ରିଭିୟସ ଟାରେ ଫାଷ୍ଟ ଆସଲ୍ଟ ରେ 2 ଜଣ ରହିଲେ ଏଟାରେ ମିଶିଗଲା
এটা
So the very
ତା-
fact,
So facts
we
are ଜାଣିଲେ
got
ଯେ
to
ଲୋକଟା
the
involve
witness
ନାହିଁ।
of evidence to be given to this person.
ଏଇ ଯେ ତାପରେ ଆସୁଛି ଯୋଉଟା 254 ରେ ନବୀନ ଦେଉରୀ, ହୃଦମାନନ୍ଦ ଦେଉରୀ, ଟାଙ୍ଗିଆ ଓ ଛୁରୀରେ ଏଠି ଗୋଟେ ଆଡ ହେଇଛି ହେଲା।
ସେ ଦେଖିନି second hand information, but the persons who have seen, they have been examined, and that happens to the evidence. Inquest ଟା କଣ evidence?
ଟିକେ କୁହନ୍ତୁ। ଏଟା 14 ନମ୍ବର ଏସଡି ଏଣ୍ଟ୍ରି ହେଲା 14 ଟାଇମ ପ୍ରିପାରେସନ 5:15 5:45 ଏ ଉପର ଫାଷ୍ଟ ପେଜ ଟାକୁ ପଳେଇ ଆସନ୍ତୁ ଯୋଉଟା ପ୍ଲେସ କରୁଥିଲେ।
ମୋର ଶାଶୁ ମା
ନାଇଁ ସେଇଟା ନୁହେଁ ମୁଁ ଏଇ ଯୋଉ 1 ନମ୍ବର କଲମ ଟା ସେ ତିନିଟା ଆକର ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟ ରୁ କୋଉଟା ପ୍ରଥମେ ପ୍ରିପେୟାର ହେଇଛି କହିଲେ? ପ୍ରଥମେ ପ୍ରିପେୟାର ହେଇଛି 253 ପେଜ ଟା ଦେଖନ୍ତୁ। ଟାଇମିଂ ଟାଇମିଂ ଦେଖନ୍ତୁ 5:15 ରୁ 5:45
5ଟା 5:15 5:45
ତାପରଟା ହଉଛି 252 ପେଜ 5:50 ରୁ 6:15 ଇଏ ହଉଛି 2 ନମ୍ବର। ତାପରେ 3 ନମ୍ବର ଟା ହଉଛି ସେଇଟା 6:55 ରୁ 7:40 ହେଲା। ଏଇ 6:55 ରୁ 7:40 ଏଟା ହଉଛି ସେ ଯୋଉଟା ପଡିଆରେ ପଡିଥିଲା ଗିରିଧାରୀ ସାହୁ। ସେ କହୁଛନ୍ତି ମୁତାଫା ଗିରିଧାରୀ ସାହୁଙ୍କ ମୃତଦେହ ଲପଟା ଗ୍ରାମର ଧାନ ଚାଷ ଜମିରେ ପଡିଥିବାର ପାୟାଗଲା। ହଁ ତ ଏଇ ଦିଟା ଯାକ ସ୍ପଟ ରେ ସେକେଣ୍ଡ ତାମାନେ ସେକେଣ୍ଡ ସ୍ପଟ କୁ ପ୍ରଥମେ ଆସିଛନ୍ତି ନଳକୂପ ପାଖରେ ସେଠି କାମ ସାରି ତାପରେ ସେ ଯାଇଛି ଏଠିକି ବିଲକୁ ଯାଇକିନି ଇଏ କରିଛି।
ସେଠି ଯେତିକି ଇଞ୍ଜୁରି ତାଙ୍କ ଦେହରେ ଅଛି ତା ମାଇଣ୍ଡରେ ଥିବ କି ଛୁରୀ ଫୁରୀ ୟୁଜ କରିଛନ୍ତି ଲେଖିଦେଇଛି।
ଏଇଠି ସେ ଯୋଉ ଆର୍ଗୁମେଣ୍ଟ ଗୁଡାକ ଆଡଭାନ୍ସ ହୁଏ ଯେ କେସ୍ ତ ରେଜିଷ୍ଟର୍ଡ ହେଲା ଆପଣଙ୍କର ସେ କହୁଛି ଗୋଟାଏ ବେଳେ ରାତିରେ ଫେରିଲା ଇଏ କୁ ତେଣୁ ଓବିୟସଲି 21 ତାରିଖରେ ଇଏ ବନଥିବ ଇଏ ଉପରେ ମାନେ କେସ୍ ନମ୍ବର କେମିତି ପଡିଲା କେସ୍ ନମ୍ବର ଟା ପରେ ପକେଇଥିବ ଆଉ କଣ ମାନେ ପିଏସ୍ କେସ୍ ନମ୍ବର ଟା ପିଏସ୍ କେସ୍ ନମ୍ବର ଟା ପଡନି କି ଉପରେ ସବା ଉପରେ ପିଏସ୍ କେସ୍ एसडी नंबर पड़ी पीएस केस नंबर इनफैक्ट पड़ीनी। अच्छा
that was not PS case ଟା ସେ ରାତି ଗୋଟେରେ ଥାନାକୁ ଗଲେ that she has explained we don't carry those registers
अच्छा एसडी नंबर ପାଇଁ କଣ ସେ କହିଲା କେମିତି ଏସଡି କାକୁ ପଠେଇଲା ଇନଫର୍ମେସନ ଦେଇଦେଲା ନା
that is nothing on record
ନାଇଁ ଏମିତି ମାନେ ଏଫଆଇଆର ସେଠିକି ନ ଗଲା ପର୍ଯ୍ୟନ୍ତ ତ ରେଜିଷ୍ଟର୍ଡ ହେଇପାରିବନି ହି ହିମସେଲ୍ଫ ଇଜ ଟୁ ରେଜିଷ୍ଟର୍ଡ କାରଣ ଏଠି ମଧ୍ୟ ନାଇଁ ଏଇ ଯୋଉ ଏସଡି ଏଣ୍ଟ୍ରି ଟା ଆଗରୁ ହେଇଯାଇଥିବ ବୋଧେ ତା ପୂର୍ବରୁ ସେ ଆପଣ ଏଠିକି ପଳେଇ ଆସନ୍ତୁ ପେଜ 19 କୁ ପଳେଇ ଆସନ୍ତୁ ଫାଷ୍ଟ ପେପର ବୁକ୍ ର सेकंड पेज को पढ़ा 19 देखो आट दी स्पॉट लिखा है 4:20 देखो 4:20 तापर से कौन लाइन है सेटा कंप्लीटली पढ़ंतु रजिस्टर्ड ए केस भाई मोहुपाली पीएस केस नंबर एसडी नंबर 14 and left receive the report at the spot को ऐसे रिसीव कला cognizable offense make out कला हाँ महुलीपड़ा पीएस केस नंबर है एसडी महुलीपड़ा पीएस एसडी नंबर है स्वांसो took up investigation of the case copy of the FIR will be supplied to the complainant obviously after the registration of the case then तापर से next time भी दोची FIR रे सेडा से सब इन्वेस्टिगेशन से दिनर सारी किनी गला परे राती 1:28 रे थाना रे पहुंची निजे एफआईआर रेजिस्टर्ड करजी ता नंबर होची 175 डेटेड स्वांसो राइट तेणु ए जो एसडी नंबर टा ही पकेइची जोटा को माने इनक्वेस्ट रिपोर्ट रे ऑब्वियसली डेड बॉडी चालान से करछि कि नाही कि ता पर दिन पठेइची जणा पड़नी के डेड बॉडी पई चालान केबे हेची ता पर दिन ना सेही दिन एविडेंस रे देखिले आईओ रो
because I am reading the IO very fast paragraph the IO stated on 21st 10 2020 I was working as IIC of police Mohulipalli PS on that day at about 3:10 p.m. while I was on patrolling duty with the staff got an telephonic information from an unknown person regarding commission of murder of 3 persons at village Lapora. I immediately reduced the same in writing in Mohulpalli PS GD number 14 dated 21/10/2020 and proceeded to village Lapoda with star. On reaching at village Lapoda, I went to the spot where the dead body of deceased Pirovati Behera was lying. The spot is locally called Jagya Mandapa. The informant Maniko Pushit was present with the other villagers. The written report has already prepared by him and he presented the written report to me at the spot. I have gone through the FIR which making out a cognizable case against the accused persons named in the FIR and for which I immediately took the charge of investigation. I examined the informant and other witnesses at the spot. I visited the spot and called the scientific team from DFSL Sambalpur for collection of physical clues. The dead body of Savitri Sahu was lying 40 feet away from the first dead body, and the dead body of Giridhari Sahu was lying around 700 meters from the second dead body. I conducted inquest over the dead body of Savitri Sahu in presence of the witnesses during 5:15 to 5:45 p.m. This is the said inquest report already marked as Exhibit P3, and this is my signature on it, marked as Exhibit P by 6. On the same day during 5:50 till 6:15 p.m., I conducted an inquest over the dead body of second deceased, namely Pirobati Behra. This is the said inquest report already marked as Exhibit P2. On the same day during 6:50 till 7:40 p.m., I conducted an inquest over the dead body of third deceased, namely Giridhari Sahu. This is the said inquest report already marked as Exhibit P4. On the same day at 8:15 p.m., the scientific officer arrived and collected the material object from the spot. I remained the night of 21/10/2020 at the village as there was a serious law and order situation there. In the intervening night of 21st, 22nd, 10/2020 at 12:30 a.m., I dispatched all the 3 dead bodies to SDS Kuchinda for PM
সেই
examination.
দিন রাত্রিরে
See that. This is the dead body challenge in respect of deceased Savitri Sahu, Maharaj Exhibit P22.
ଆପଣ ପଳେଇ ଆସନ୍ତୁ ସେକେଣ୍ଡ ପେପର ବୁକ୍ ର ପେଜ 238 କୁ ପଳେଇ ଆସନ୍ତୁ
30 minutes.
238
Yes, yes.
ଏଇ ଗୋଟା କହୁଛି ସେ ଯୋଉ ସାବିତ୍ରୀ ସାହୁର ଉପରେ ନମ୍ବର ପଡିଛି ଦେଖନ୍ତୁ
Right.
ସେ ଯୋଉ ଚାଲାଣ ଫର ୟୁଜ when the dead body is
Yes,
sent
yes.
for examination ସେଇ ଷ୍ଟେସନ ଡାଇରୀ ଏଣ୍ଟ୍ରି ନମ୍ବର ହିଁ ପଡିଛି
Yes.
ତାମାନେ ସେ ପର୍ଯ୍ୟନ୍ତ ପିଏସ୍ କେସ୍ ରେଜିଷ୍ଟର୍ଡ ହେଇନି ରାଇଟ୍
And time is also 12:30.
ଟାଇମ ଟା ମଧ୍ୟ ପଡିଛି 12:30 ରେ
Yes.
dispatch of from the village 7 number column
Yes, yes. On 22nd 10/2020 at 12:30.
21-22 ର ରାତି 12:30 ହବ
Right.
yes
On 240 ହଉଛି ପିରୋବତୀ ବେହେରାର dead body challenge.
ହୁଁ।
Page 240 and 242 Giridhari Sahu.
ଆଚ୍ଛା ତାପରେ ଯୋଉ ତାର ଗୋଟେ ପାର୍ଟ ଅଛି ସେଇଟା ଗୋଟେ ପଢନ୍ତୁ 238 ର 239 ପେଜ କୁ ଆସନ୍ତୁ ଯୋଉ ପଠେଇଲା କଣ ଲେଖିକିନି ପଠେଇଲା
Yes.
ସେଇଟା ଇମ୍ପୋର୍ଟାଣ୍ଟ ଅଛି ପଢନ୍ତୁ
To the ADMO.
SDMO
Sahu, alias Behera, wife of so office also. Sir, in sending here with the dead body of the above noted deceased to you and beg to state you that on 21st and 2020 at 3 p.m. the above noted deceased was filling water in her water bottle and her mother operating the tube well handle. At that time, the accused person, namely Navin Devri and his son Hemanand Devri, assaulted her by an axe blow repeatedly. So the deceased died in the village road due to chronic land dispute. The accused person also killed her husband and her mother. Hence, this case. During course of investigation, the spot has been visited by utilizing scientific team. Conducted inquest over the dead body of the deceased in presence of witnesses and sending to you for autopsy. Please conduct autopsy over the dead body of the deceased and to opine the cause, nature, and duration of death. Further, it is requested plus sample blood. It is required so sample blood
sealed condition
in sealed condition. In dry condition.
So false.
Nail scraping and sample hair may kindly be collected and handed over with the wearing apparels for chemical examination. Any other examination required may kindly be done.
ଏଇଟା ହଉଛି ଝିଅର ଡେଡ୍ ବଡି ଚାଲାଣର ଫରୱାର୍ଡିଂ ରିପୋର୍ଟ।
Yes.
ତାପରଟା ହଉଛି ମାର
ତାପରେ
ସେମ୍ ଜିନିଷ ଲେଖା ହେଇଛି,
Yes.
ଯୋଉଟା 240 ରେ ଆରମ୍ଭ ହେଇଛି
ତାପରେ
ସେଇଟା ହଉଛି ପୀରବତୀର।
ତିରୁପତି
ଆଉ ପୀରବତୀର ସେଇ ଜିନିଷଟା ପ୍ରାୟ ସମାନ ଅଛି ସେ ଯୋଉ ଫରୱାର୍ଡିଂ ରିପୋର୍ଟର ଏକ୍ସଟ୍ରାକ୍ଟଟା। ନାଉ ୟୁ କମ୍ ଟୁ ଦି ଗିରିଧାରୀସ୍ ହାଉସ୍, ଯୋଉଟା ହଉଛି 242 ରେ ଅଛି। 242 ରେ ସେମିତି ସେଇ ଏସଡି ନମ୍ବର ପଡିଛି, ବଟ୍ ତାର ଇଏଟା ପଢନ୍ତୁ, ସେଇ ଯୋଉ forwarding report. The next page.
In sending herewith the dead body of the above noted deceased to you, and beg to state you that on 21st 10 2020 at about 2:30 p.m. the above noted deceased
Had been to.
Had been to his agricultural land for cutting the crops. On the way, in the agricultural land of Kondadhar, se local jaga jo bill se padichi, Kondadhar Patel, the accused Navin Deori and his son Hemanand Deori assaulted him by means of axe blow repeatedly to his body due to chronic land dispute. So the deceased died there. Then after the accused person came to village and also killed his mother-in-law and wife. Hence this case. During course of investigation, the spot has been visited by utilizing scientific team, conducted inquest over the dead body of the deceased in presence of witnesses and several uh, and sent to you for autopsy. Please conduct autopsy over the dead body of the deceased and opine the cause, nature and duration of death. Further, it is requested requisition or request something sample blood in seal gauze, in soaked gauze, in dry condition, nail clippings and sample hair may kindly be collected and handed over with the wearing apparels for chemical examination. Any other examination required may kindly be done for the interest of prosecution.
ଏଇ ଯୋଉ ଇନଫରମେସନ ଟା ଲେଖିଛି ଯେ 2 ଜଣ ଯାକ ମାରିଲେ, ବିକଜ ଏଫଆଇଆର ରେ ହିଁ କହିନାହାନ୍ତି ସେମାନେ ଗଲେ ଅଟରିଂ କଲେ ଯେ ଆମେ ମାରିକିନି ସେଠି ପକେଇ ଦେଇଛୁ କିରମିରିଆକୁ ତାକୁ ହାଣି ଦେଇଛୁ, ସେଇ ବେସିସ ରେ ସେ ତାକୁ ଏକ୍ସଟ୍ରାକ୍ଟ କରିକିନି ଲେଖିକିନି ପଠେଇଲେ। ଯଦିଓ PW5 ର ଏଭିଡେନ୍ସ
Statement
ଅଛି
ରେ
only one person, Naveen assaulted. Yes.
Yes, I'm relying with the judgment of Supreme Court on inquest.
Inquest, acha.
Purpose of holding inquest, that is 2011.
Just a minute. Purpose of
holding inquest.
2011.
2011, volume 6, SCC.
Yes.
Page 288, 288.
Which paragraph?
That is plus paragraph 8 to 13.
8 to 13. Patina gana kondu?
Brahma Swarup and another. Brahm Swarup. BRHM.
Brahm Swarup.
Yes. And
versus?
Another. Versus State of UP.
State of. Dejan bhai. Yeah. 8 ରୁ 13. Right. Hold on.
Undoubtedly, there are 5 blanks in the inquest report. The crime number and names of the accused have not been filled up. The column, in that case, of course, the column for filling up the penal provisions under which offences have been committed is blank. The time of incident and time of dispatch have not been mentioned. Relevant para 9. The whole purpose of preparing an inquest report under section 174 of the Code of Criminal Procedure 1973 is to investigate into and draw up a report of the apparent cause of death, describing such wounds as may be found on the body of the deceased, and stating as in what manner or by what weapon or instrument such wounds appear to have been inflicted. For the purpose of holding the inquest, it is neither necessary nor obligatory on the part of the investigating officer to investigate into or ascertain who were the persons responsible for the death. The object of the proceedings under section 174 CRPC is merely to ascertain whether a person died under suspicious circumstances or met with an unnatural death, and if so, what was its apparent cause. The question regarding the details of how the deceased was assaulted or who assaulted him or under what circumstances he was assaulted is foreign to the ambit and scope of such proceedings. That is the
ଯଦି ବି ସେଠି ଲେଖା ହେଇଥାନ୍ତା
ହଁ।
ସିଏ ଲେଖିଥାନ୍ତା ସନ୍ଦେହ କରାଯାଉଛି କୌଣସି ଧାରୁଆ ଅସ୍ତ୍ର ଦ୍ଵାରା ବା ସନ୍ଦେହ କରାଯାଉଛି ଛାଡି ଦିଅନ୍ତୁ କୌଣସି ବା ଟାଙ୍ଗିଆ ଦ୍ଵାରା ମରାଯାଏ କାରଣ ଏଠି ଆଇ ୱିଟନେସ୍ ଅଛନ୍ତି ତାଙ୍କଠୁ ଶୁଣିଛି ସେତିକି ବି ସଫିସିଏଣ୍ଟ ହେଇଥାନ୍ତା ମାନେ ନାଁ ଲେଖିବା ଦରକାର ନାହିଁ
ଦରକାର।
ହଁ
Yes.
ତେଣୁ କେମିତି ମାଡ଼ ହେଲା ସେଇଟା ବି ଦରକାର ନାହିଁ ମାନେ apparent cause of death
Yes.
ମାନେ homicidal
ହେଲା,
death କି
suicide.
ଗୋଟେ ସନ୍ଦେହ ହଉଛି suicide କଲା କି କଣ ଏଇ ସବୁ apparent cause of death ଟା opinion of witness କୁ gather କରିକି ଲେଖିବା
Yes. The question regarding the details of how the deceased was assaulted or who assaulted him or under what circumstances he was assaulted is foreign to the ambit and scope of such proceedings. That is, the inquest report is not the statement of any person, wherein all the names of the persons accused must be mentioned. 10. Omissions in the inquest report are not sufficient to put the prosecution out of court. The basic purpose of holding an inquest is to report regarding the apparent cause of death, namely whether it is suicidal, homicidal, accidental, or by some machinery, etc. It is therefore not necessary to enter all the details of the overt acts in the inquest report. Evidence of eyewitnesses cannot be discarded if their names do not figure in the inquest report prepared at the earliest point of time. The inquest report cannot be treated as substantive evidence, but may be utilized for contradicting the witnesses of inquest. 11. In Radhamohan Singh, a three-judge bench of this court has held no argument on the basis of an alleged discrepancy, overwriting, omission, or contradiction in the inquest report can be entertained. Only the attention of the author thereof is drawn to the said fact, and he is given an opportunity to explain when he is examined as a witness in court. Verse 12. Even where the attention of the author of the inquest is drawn to the alleged discrepancy, overwriting, omission, or contradiction in the inquest report, and the author in his deposition has also admitted that though a mistake he omitted to mention the crime number in the inquest report, this court has held that just because the author of the report had not been diligent didn't mean that reliable and clinching evidence adduced by the eyewitnesses should be discarded by the court. In view of the law referred to herein above, it cannot be held that any omission or discrepancy in the inquest is fatal to the prosecution case, and such omission should necessarily lead to the inference that FIR is anti-time. So that is not good. It is para 9 and 10 more important. Plus 9, 10, 11.
ଏଇ ଯୋଉ ଗୋଟେ ଲୋକଟାର ଯୋଉ କଟା ହେଇଛି
Yeah.
ତୃତୀୟ ଆକ୍ୟୁଜ ଟା ଯିଏ ସେ ଯୋଉ ଇଏ
ନାଇଁ
ନାଇଁ ତାକୁ ପଚାରିଛନ୍ତି ଏ ବିଷୟରେ ପଚାରିନାହାନ୍ତି ଯେ ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟରେ ଏଇଟା ଲେଖିଥିଲ କାହିଁ କଣ ପାଇଁ କାଟିଲ
କିଛି ପଚରା
ଏ କ୍ୱେଶ୍ଚିନ୍ ନ ପଚାରିଲେ ହାଉ କ୍ୟାନ୍ ୟୁ ୟୁଟିଲାଇଜ ଇଟ୍
ଭେରିଫାଇ
ଖାଲି କ୍ୱେଶ୍ଚିନ୍ ଟା ପଚରା ହେଇଛି ଯୋଉଟା ଆଇଓ ଆଡମିଟ୍ କରିଛି ଯେ ୟେସ୍ ଇଟ୍ ୱାଜ
ନାଇଁ ନାଇଁ ନାଇଁ
ୟେସ୍ ଇଟ୍ ୱାଜ ଆଇଓ
ଆୟୁ ନୁହେଁ ମ ଯିଏ ଲେଖିଛି ଯିଏ ଅଥର ସେଇ ଯୋଉ ଲାଇନ ଟା 9 ନମ୍ବର ପାରାଗ୍ରାଫ ଟାକୁ ଲେଖିଛି ପୂରଣ କରିଛି 2 ନମ୍ବର ସାକ୍ଷୀ ପରା ହଁ 2 ନମ୍ବର ସାକ୍ଷୀକୁ ପଚାରିଛନ୍ତି ଆପଣ ଯେ ବାବୁ ଏଇଟା ଲେଖିଥିଲୁ କାହିଁକି ଏଇଟା କାଟିଲୁ କଣ ପାଇଁ
No, it's not there.
No.
P2 ର ଏଭିଡେନ୍ସ ଆଉ ଗୋଟେ କଥା ଆସୁଛି ଯେ ସେ ତା ପୂର୍ବ ଦିନ ଆଣି ତା ୱାଇଫ କି ଲାପଦାରେ ଛାଡିଛି that part is there plus page 71 from evidence of P2
କୋଉ ଲାଇନ ଟା
that is plus it is 1 2 3 4 5 sixth line from the top in the chief examination from the beginning
on the previous day
on the previous day
I had left
my wife in her father's house at Lapada on
wife
that
means
day
PW1
yes
Hmm.
then everything hearsay
ମୁଁ ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟ ବିଷୟରେ କୋଉଠି କହିଲା ଯୋଉ ଲେଖିଲା
inquest report କହିଛି ଯେ
Inquest
Pass
72
first
as per our second part.
70
My wife lodged a written report to police. Police held inquest over the dead bodies and accordingly reports were prepared at the spot. I had put my signature on the inquest reports.
for that part.
Only that is there. କିଛି ନାହିଁ.
ନାଇଁ ଜିଆର କିଛି ବାହାର କରନା ନା
ନାଇଁ, there is no.
P2 is it P3
And he produced the records. That is para 5, page 73. Land records was produced by him, seized and handed over to him.
I was lying on the Chandani of the mother. No, nothing has been put on. It's inquest.
କାହାର ଇଏରେ କଟାକଟି ହେଇଛି ଯୋଉଟା ଗୋଟେ ତୃତୀୟ ଆକ୍ୟୁଜ ଯୋଉ ପୁରେଇକିନି ଯୋଉ କାଟିଲା ସେଟା କେତେ କାହାର ଇନକ୍ୱେଷ୍ଟ ସେଟା କାଟିଛି
ସେଟା ମାର
ମାର
এটা ହେଇଛି କଥା।
240.
ନା এটা ହେଇଛି ଇଆର ମୋର ନାନୀ ସାବିତ୍ରୀ ସାହୁ।
ଏଇଟା ରିପୋର୍ଟ ଅଫ ସାବିତ୍ରୀ ନା ସାବିତ୍ରୀ ମାନେ ଏକ୍ସିବିଟ୍ ସେଟା
Savitri means the
ଏକ୍ସିବିଟ୍
daughter. ସେଟା ସାବିତ୍ରୀ ର ଇଏ ଦେଇଛି 253.
ଜଷ୍ଟ
Because FIR that mother was also there. That's one word was
We were
there.
following.
yes they could have even implicated the mother
Name is there in the FIR.
But she was following.
Yes.
that
They
we
will- Ani-
are on a total different point. What he is arguing your Mr. Sorangi যেটা କଟା ହେଇଛି ତେଣୁ ଆଗରୁ ଆପଣଙ୍କୁ ସେ ୱିଟନେସ୍ କୁ ଯେ ପର୍ଯ୍ୟନ୍ତ ପଚାରି ନାହାନ୍ତି ଯେ ଏଇ ଯୋଉ ଲେଖାଟା ହଉଛି ଆପଣଙ୍କର ଲେଖା ଏଇଟା ଆପଣ ଲେଖିଥିଲେ କାଟିଲେ କଣ ପାଇଁ ତାକୁ ଯେ ପର୍ଯ୍ୟନ୍ତ ଅପରଚ୍ୟୁନିଟି ଦିଆ ହେଇନି it cannot be utilized.
Yes.
That is
that's correct
he might have explained it ଯେ ଏଇ କାରଣ ପାଇଁ ମୁଁ ଲେଖିଥିଲି କାଟିଦେଲି ତେଣୁ
and suggestions plus whatever has been given to PW1 and PW3 will also be kindly appreciate. PW70 plus what suggestion, nature of suggestions. It is not a fact that the deceased persons were not killed by the accused persons and they died coming into contact with the harvester, the machine which is being used to cut the paddy crop. And as we have had land dispute with the accused persons, we have falsely implicated them in this case. This is the nature of suggestion. And a different suggestion has been given to PW3. There notes at paragraph 9 saying it is not a fact that my father died during fighting of bullocks and that the horn of the bullocks pierced inside his body and my mother and maternal grandmother died by coming into contact with the harvesting machine. There these type of suggestions are given. If we will take it as a please, defense please suppose plus by taking different pleas, each plea is false. So they are taking false pleas every time.
inconsistent
Inconsistent.
and during one accused statement ଖାଲି ମିଛ
Yes, ମିଛ.
total ମିଛ
Yes.
ସେଇ ଯୋଉ ସଜେସନ ବାବୁ ଜଣକ ଦେଇଥିଲେ ଡିଫେନ୍ସ କାଉନସିଲ ସେ ଭାବିଛି ଆଗେ ଦେଇଦବା ଆଗେ
please, so far as the field occurrences in the field, that plea is there, that some animal. So far as the tube well, it's harvesting machine. That they have done because the doctor, page 89, has said the injuries sustained by these ladies is possible if they come in contact with the harvesting machine.
That is already there, but for that the foundation has to be
harvesting
there.
machine ସିନା ସେଥିରେ ଥିଲେ ହବ
Harvesting machine
ତୀର
ଟା
ନାସ୍ତି
ଥିଲା।
ତୀର ପିଡା ହେଲେ କଣ ହବ
ନାଇଁ
ମୂଳରୁ ହାର୍ଭେଷ୍ଟିଂ ମେସିନ୍
ଥିଲା, field ରେ ଥିଲା, PW5 ର।
ଆପଣ ଟ୍ୟୁବୱେଲ ପାଖରେ ଯାହାକୁ ସଜେସନ ଦଉଛନ୍ତି ଯେ ହାର୍ଭେଷ୍ଟିଂ ମେସିନ୍ ଟ୍ୟୁବୱେଲ ପାଖରେ
ସେଠି ହାର୍ଭେଷ୍ଟିଂ ମେସିନ୍ ଟା ଏଠି ସେଟା
If you also take it as please, then each plea is false. If you also take it as please, then a different plea, then each plea is false.
ନାଇଁ ସିଏ ଏଇ ଯୋଉ ରାଣ୍ଡମଲି ପଚରା ହେଇଛି ଚିନ୍ତା କରାଯାଇନି ଯେ ଆମେ କଣ ପ୍ଲି ଟା ନବୁ ଡିଫେନ୍ସ ପ୍ଲି ଟା ମାନେ ଇଟ୍ସ ମୋଷ୍ଟ ଇମ୍ପୋର୍ଟାଣ୍ଟ ଥିଙ୍ଗ ଆପଣ डिनायल नहीं अलगा कथा जदि गोटे स्पेसिफिक नौचंती इट शुड बी कंसिस्टेंट एवं आपण चेष्टा करिवे केते जिंस आपण साकु सपोर्ट करिया को अन्य थ्रू रे बाहर करिकिन आनी हाँ जिनस गुड़ा सब बाहर करी आनी तापरे जोटा गढ़ मंदिर भाया गढ़ंती ताकू लास्ट आर्गुमेंट रे फोकस करिकिन छाड़िबे जे इटा हूँ आमर प्ली सपोर्ट एटा ये तेणु आसीगला एटा हूँ आमे आमर दायित्व नुह ताकू बियॉन्ड ऑल रिजनेबल डाउट ये करिवा हम प्री प्रोंडरेंस प्रोबेबिलिटी तेणु एठी ये कहूँ तेणु ताकू न चिंता करी गोटे गोटे दे गोटे सजेशन दे दे एठी गोटे दे दे सेठी गोटे दे दे सेमती कले आसीबनी
And keeping in view the nature of your plea,
Yes.
if necessary, also positive evidence is
It will
required.
yes.
it may be through the defense
Yes.
witness it may be through the prosecution witness
Yes.
Yes.
a
First prosecution.
prosecution
prosecution-
witness गुड़ाक tactfully आणती जोड़ाक अक्तियारे चली आसी थाए तांकू होस्टाइल फोस्टाइल न होला सेइथरु खसेकिन दी तीनटा खंडा कथा बाहर कर दियंती
आंगुर देखिକି ଦିଟା ଆଙ୍ଗୁଠି
जोड़ा की
ଦେଖେଇକି।
हेल्प करियो तांकू yes next
Plus, I am taking lordship to for the doctor who has conducted the PM examination. The lordship has gone to just
PW6 परा कहले
PW6 at page 86.
Dr. Satyaprakash.
The injury sustained by Sabitri Sahu, lordship will get it at page 87, paragraph 4. This is well corroborated by the deposition of PW1.
1 2 3 3 chopped wound
Yes, 3 chop wound. And you'll also can see the where he has given the chop wound and how merciless that person Nobin is. On external examination, I found a stout female dead body, bilateral eyes closed, mouth open, rigor mortis had developed in all 4 limbs and neck muscles, and chopped wound of size 6 cm into 3 cm and into 3 cm over right cheek, 1 cm in front of right ear. One chopped wound of size 4 cm into 3 cm into 3 cm over left cheek. One chopped wound of size 6 cm into 3 cm into 3 cm over base of right side of neck.
right side neck रे 3 cm भितरु पस्तो माने से
A heavy blow has been. The daughter nurse. And to the mother, plus 1 blow and sufficient was 6 cm into 4 cm and 4 cm on the neck at cervical vertebra number 4 level. कोटे तक पूरा कटि जाई टिके खाली स्किन रे झुलतला. Paragraph 7.
no 6 ରୁ जोड़ा पडुचंदी
Yes, sir. 6 रो page 87.
spinal cord incised completely अच्छा
Yes.
okay I also एवं आ गोटे 7 नंबर रे कहउचंदी इंटरनल इंजुरी टा जोटा कहउचंदी
Yes.
चॉप वुंड 6 सेंटीमीटर 600 नेक रो बैक रे 400
In post-mortem examination of Giridhari Sahu. There, paragraph 9, I am reading loss. On internal examination, I found skull fractured at left temporal region, 4 cm above left ear. The membrane lacerated at temporal region, 1 chop wound over brain of size 2 cm into 1 cm at temporal region, 1 hematoma of size 1 cm into 1 cm into 1 cm present at temporal region. Bilateral lungs were intact and congested. Heart was intact and filled with clotted blood. Stomach intact and filled with partial digested food. Large intestines were intact and filled with gas and paragraph 10 I am coming last. On external examination, I found 1 chop wound of size 4 cm into 3 cm into 1.5 cm over base of left scapula. 1 cm lateral to midline. 1 chop wound of size 4 cm into 3 cm into 1 cm on posterior base of neck at cervical vertebra at number 6 level. 1 chop wound of size 4 cm and 3 cm into 1 cm over left temporal lobe of head. 4 cm above left ear.
माड़ गुड़ा सब ऊपर यारी ऊपर भीतर कन्फाइन
सब नेक हाउस
हेड
ପଛରୁ ଯାଇକି ମାରିଛି. In a very planned way, he has murdered.
Cause of death was due to multiple chop wounds.
Multiple chop wounds over head and neck by heavy sharp weapon. Times in death within 24 hours postmortem examination. Nature of death is homicidal.
ऐसे
This is
जो
very important.
मैंने ଅଛନ୍ତି ତ ଆଜି ପ୍ରେଜେଣ୍ଟ ଅଛନ୍ତି ଚେକ୍ କରିଦେଇଥିଲ ତ ନା ଠିକ ଅଛି ଜଷ୍ଟ ଦେଖିଥିଲ ଅଛନ୍ତି ତ ଏଟା ପ୍ରଥମରୁ ଚେକ୍ କରିଦବ କଣ that is the କଣ ଜଷ୍ଟ ଦେଖିବା ପାଇଁ
ସମ୍ବଲପୁର ଜେଲ୍ ଅନମ୍ୟୁଟ୍ କରନ୍ତୁ।
ସମ୍ବଲପୁରରେ ଅଛନ୍ତି ମାନେ advocate ଅଛନ୍ତି ତ ଠିକ ଅଛି ଯାହା ଆର୍ଗୁମେଣ୍ଟ ହଉଛି କ୍ଲିୟରଲି ଶୁଣା ଯାଉଛି ତ ଠିକ ଅଛି ସେଇ ବିଷୟରେ ତାଙ୍କୁ ଟିକେ ବୁଝଉଥିବେ କଣ ଆର୍ଗୁମେଣ୍ଟ ହଉଛି ସେ ଦି ଜଣଙ୍କୁ ହେଲା ଯାହା ସେ ଯଦି କହିବାକୁ ଚାହିଁବେ ଆଡଭୋକେଟଙ୍କୁ କହିବେ ହେଲା ଠିକ ଅଛି ଓକେ
So one query actually. The accused number 2, Hemanand Devuri, he is repeatedly telling कि तारा ଗୋଟେ private advocate engage ହେଇଥିଲେ और ସେଇ ବିଷୟରେ କିଛି ଜାଣିବାକୁ ଚାହୁଁଥିଲେ कि whether they say sir conduct the case or only suddenly sir is taking off the case.
ପ୍ରାଇଭେଟ ଆଡଭୋକେଟ ତ କେହି ଏନଗେଜ ହେଇନାହାନ୍ତି ସେଇଥିପାଇଁ ତ ଆମାଇକସ୍ କ୍ୟୁରି ଇଏ ହେଇଛି କୌଣସି ଏନଗେଜ ହେଇନାହାନ୍ତି
Thank you.
This is only for Hemanand.
No,
The second accused.
Hemanand.
Yes.
they are confused
For
that whether I'm
Hemanand, you say
appearing
that
in both
another-
or they are confused probably whether I am appearing
For
for
both or
or
not.
what.
He is appearing for both.
Yes. Actually, I was
ଦି
telling
ଜଣ
you.
ପାଇଁ ଆର୍ଗୁମେଣ୍ଟ କରୁଛନ୍ତି
Yes.
ମିଷ୍ଟର ଷଡଙ୍ଗୀ ଦେବାଶିଷ ଷଡଙ୍ଗୀ ଦି ଜଣଙ୍କ ପାଇଁ ଆର୍ଗୁମେଣ୍ଟ କରୁଛନ୍ତି
Yes.
ହେଲା
Yes, your lordship.
My lord may also direct that any affidavit he will prepare and
ହଁ ନାଇଁ ସିଏ ତ କହିବେ ତାଙ୍କୁ ଆଜି ଆମ ଅର୍ଡରଟା ହେଇନି ତ ଏପର୍ଯ୍ୟନ୍ତ ତାଙ୍କୁ କହିବା
Yes, your lord, sir will.
And he must have heard, ତାଙ୍କୁ କହିଦେବେ ସେ ମଧ୍ୟ ଶୁଣିଥିବେ ତାଙ୍କର ଆର୍ଗୁମେଣ୍ଟ ସେ କଲା ବେଳକୁ ଗୋଟେ ପରେ ଗୋଟେ ସେ କରୁଥିଲେ
Yes.
ଆଗେ ହେମାନନ୍ଦ ଉପରେ କରୁଥିଲେ ତାପରେ
Yes.
ନବୀନ ଉପରେ ବି କରୁଥିଲେ
Sir, ମୁଁ detail ତାଙ୍କୁ ବୁଝେଇ ଦେବି କି sir totally
ହଁ,
in the case.
ଠିକ ଅଛି ଆଜି ଆମେ ଗୋଟେ ବି ଅର୍ଡର ପାସ୍ କରିବୁ ଯୋଉ ଉପରେ ତାଙ୍କୁ କୁହାଯିବ ଆଫିଡେଭିଟ କରିକା ଦବାକୁ ସେ ଅର୍ଡରଟା ମଧ୍ୟ ଯିବ ଜେଲ ସୁପରିଟେଣ୍ଡେଣ୍ଟଙ୍କ ପାଖକୁ ଯିବ ସେ ଅନୁଯାୟୀ ସେ ରିପୋର୍ଟ ମଧ୍ୟ ଦେବେ ସେ ଅର୍ଡର ପାସ୍ ହବ ଆଜି ହେଲା ଓକେ ୟେସ୍ ପ୍ଲିଜ ପ୍ରୋସିଡ୍
So, it's nature of death is homicidal. This is my report, Maharaj Exhibit P9. That is available at page 249.
ମାଇକଟା କୁଆଡେ adjust କରୁଛ ତ ଟିକେ
Are
କୋଉ ପର୍ଯ୍ୟନ୍ତ ହଁ ପ୍ଲିଜ
yes, I'm taking lost. Paragraph 12.
paragraph 12 of
Same.
On
311 6.
yes
The query has been made to him by showing the axe. On 3rd November 2020, I was working in my present place of posting. On that day, the weapon of offense in Mahulpally PS case number 175 of 2020, that is, an axe was produced before me, and the following queries were made. Whether the injuries detected on the dead body of the deceased persons, namely Giridhari Sahu, Pirobati Behra, and Savitri Sahu, can be possible by the said weapon of offense, that is, an axe or not. If so, it is sufficient to cause death of the deceased persons in ordinary course of nature. Third, any other suggestion in this regard may kindly be opined. The length of the said axe was 54 cm. The sharp side of the iron part was 7 cm in breadth, and the blunt portion of the iron part was 4 cm in the breadth. The circumference of the wooden part was 7.5 cm. The weight of the axe was 574 grams. There was a crack on the wooden handle. Answer of queries. I verified the injuries and submitted my opinion on the said queries as follows. Yes, the injury detected by me in the post-mortem report of the above named deceased persons can be possible by the seized weapon of offense, that is, an axe. 2. It is sufficient to cause death of the deceased persons in ordinary course of nature. Exhibit P10, that will be available as 250 minutes. Is the requisition along with my opinion on the queries with objection. And if P10/A is my signature on it. Lordship like I can take lordship to page 250.
250 ରେ କଣ ଅଛି?
ସେଇଟା ଅଛି ସେଇ ଯୋଉ exhibit ଟା ହେଇଛି
ଓ ସେ query ଟା
queryଟା
କାଇଁ କିଛି discrepancy ଅଛି ନା କଣ?
second paper ବୋଧେ ସେ acts ଟା ବି ଦେଖା ହେଇଛି
250
250 of the part 2 volume 2.
volume 2.
Yes.
If so, is it sufficient to cause death of the deceased in ordinary course of nature? এটা হচ্ছে query ହେଲା
Yes.
ତାଙ୍କର reply ଟା କୋଉଟା ଆସିଲା?
back side se ଦେଇଛନ୍ତି.
back side
Yes.
ଦେଇଛନ୍ତି. It is sufficient to cause death of the deceased in ordinary course of nature. Okay. 251. ତାର ଇଏଟା ହଉଛି 7 ସେଣ୍ଟିମିଟର
7 ସେଣ୍ଟିମିଟର
ମାର୍ଜିନ୍ ରହିଛି ଏଇଟା 4 ସେଣ୍ଟିମିଟର
ବଡ ଟାଙ୍ଗିଟା
ଟୋଟାଲ ସିଏମ ହଉଛି 54 cm
574 ଗ୍ରାମ ଟୋଟାଲ
54 cm ମାନେ এটা ସ୍କେଲଟା ହଉଛି 15 cm ମାନେ ଯୋଉ ଛୋଟ ସ୍କେଲ ଆମେ ଯୋଉଟା 15 15 15 ତିନିଟା 15 ହଁ ଏତିକି ବଡ ଖଣ୍ଡ ହବ No, homicidal death is not disputed.
Yes.
And so the in addition to that, the nature of injury shows that all are on the vital part of the body. ମାନେ ସବୁ ଗୁଡାକ ସବୁ chest ଉପରକୁ ହେଇଛି ସବୁ and except
If anything, the witness can be requested. Why it is objection?
Exhibit P10 PW6 is the requisition along with my opinion.
No objection to the
the signature. There was no necessity to record it with objection. It should have been overruled. Any objection? If X is the author of that document and he is proving that document, why should an objection be raised? Suppose somebody else would have proved that document.
Formal objection. Objection.
But
Mark
should be
that should have been substantiated.
Yes.
Absolutely.
କଣ ପାଇଁ ଅବଜେକ୍ସନ କରୁଛ ତାଙ୍କ ମୋର ଏ ଡକୁମେଣ୍ଟ ଉପରେ କିଛି ନଲେଜ ନାହିଁ ମୁଁ ଆସିକି ଗୋଟେ ଡକୁମେଣ୍ଟ ପ୍ରମାଣ କରେଇବି obviously the defense counsel raise objection ସିଏ କଣ ଆସିକିନି ରାମ ଡକୁମେଣ୍ଟ ଲାଗିଛି ସାମ କଣ ଆସିକିନି କହିବ
Here the document has been prepared by the same doctor and also he has deposed before the court.
Yes.
So medical evidence corroborates the testimony of the eyewitnesses. W7 is a hearsay evidence.
Because Mr. Bhoti and counsel, so far as this death sentence is concerned, of course, he has started his argument. But since we are calling for those reports and we are likely to fix it another day, so after receipt of the report, we'll hear about that
sentence.
The sentence finally on that day, right? So
and another part also I'll make advance my submission. regarding, because there are 3 murders,
Hmm.
3 crimes have been committed.
Hmm.
So there should be 3 life imprisonments. For each murder,
Hmm.
1 punishment should have been prescribed as per law laws.
Hmm.
It has also been decided in the, by
Because
the constitutional bench.
suppose for one he is found not guilty,
Yes,
and for the other two,
yes,
that is it is found, then it can have the impact also on the sentence part
yes.
also. So
That will be my alternative argument. Because if the death sentence, I have to argue on the alternate side.
no death sentence for we like to, of course he has we
Yes.
said that let us wait for that.
But
You finish it on merit, whatever you said.
Yes.
So far a sentence part is concerned, we'll hear only after you produce all those reports from the jail superintendent. The order will be passed today during course of the day. We'll
Yes.
pass and hand over the copy to you. Obviously, that is to be
Then your
communicated.
lordship has gone through the entire records. I can say the chemical examination report already your lordship has perused. And that was carrying blood, the axe was carrying blood, and leading to discovery there. If a lordship will go to the evidence and the document that is prepared under section 27 CRP, that also evidence act, that also I can show your lordship.
No, you are not answering some of the points he has raised, that about the absence of the names of the 2 eyewitnesses, that you are trying to cover up that any omission in that.
Yeah.
Because in the FIR it is not mentioned that 3 and 4 were present and they saw the occurrence. It is as if that only PW1, as if he had seen the occurrence. So he said 2 things apart from other things, said that not only about the that PW5 is an eyewitness, that part is not there. It is only basing on what they disclosed at the scene of occurrence, that is mentioned that murder on that Giridhari was committed by these two that appellant, but the 2 persons' names, that is not there. So
They were introduced.
they were introduced. That is his submission.
Plus, about few minutes, I can half an hour after the FIR has been lost. Like that, the occurrence has taken place around 3 or the 3:30, around that, and 4:20 the FIR has been lost. The FIR must have prepared, and that time, the state of mind of that person, whatever is there, whatever he has.
In that light you have
Yes,
placed
I have.
that.
So in minute details, she cannot describe everything. But while he was examined by the police under section 161 CRPC, she has stated everything. She has stated that both.
Because Mr. Sadangi argued that not only omissions are there, but additions are there. Some additions which you have subsequently taken away for some purpose, for some reason, and some omission which you are there, you have added it to make some persons as eyewitnesses to the occurrence, like 5, 3, 4. Okay. And what was there, you left it out, that both the persons assaulted by Tangia, that was there in the FIR, which now you have taken away, that no, one person.
All the persons have assaulted.
That argument you want to cover by that decision.
Yes, that is
because of the state of mind. Hurriedly the FIR was presented, and in that situation, their state of mind would not be that proper, calm, quiet, and stable that they would have reflected everything in detail. Apart from the fact that the law is that it is not the encyclopedia of the prosecution. Yes.
Even if she would have stated it simply that so and so, they have killed my brother-in-law, my sister, my mother, then even the FIR could have been taken into consideration, because that launches the prosecution into motion, the FIR. Then when investigation has been started, once statement have been recorded, there everything has come up. And that has been well corroborated by the evidence of PW1 and PW3 and PW4. And PW2 is a hearsay evidence. He has not seen anything else. What he has gathered from PW2, I mean PW3 or PW1, he has stated accordingly.
Who?
PW2.
Oh, PW2, right. PW2 is the husband. He came afterwards, and he was informed, and accordingly, he in that inquest report he mentioned that.
Yes.
Right.
But that is not an evidence. And he has come up, and my learned friend was arguing yesterday that he came by a different route, passing through 3 kilometers by his motorcycle. he could have reached earlier. I mean, by the time the occurrence has taken place, he should have been present there. That was the argument. If I have gathered,
Yes, sir, that is the argument.
that is the argument. But plus 63 kilometers, if one person will come by a motorcycle at a speed of 60 kilometers per hour, it will take 3 minutes. But that road, whether it is that much motorable, and whether there is traffic on the road, there are so many facts are there which are not available in the evidence. So that person can come at a speed completely with 60 kilometers per hour cannot be said. That is say as he Ponjivo. But the fact remains, the accused has traveled 700 meters and to the second spot of occurrence and assaulted Savitri and Nilavati.
The moment he reached and started
Yes.
assault.
And after assault, he said that I have killed Girdhari in the field, whose dead body is lying in the field. Thereafter, P5 has come. So, as because they have already got the knowledge of death of Girdhari, so they might not have given that much importance if at all he has said at that point of time. Because that is not that much consequential. That because that information is already with the P1 and P2 and P3 and the other persons who are present there.
Three kilometer distance टा किए कौजी?
मैं वो देखूँ स्पॉट में अपने थिक
Oh, अच्छा से
Spot.
मोटरसाइकिल आसले शीघ्र पहुंची
नवीन distance cover होची 800 feet ना कहते को जले
हाँ से कुछ चला बाटा टा 800
हाँ 700 meters
700 meters
7 to 8
approximately 800
800 meters
সেটা only spot map লে ଅଛି সেটা no oral evidence has been added
अच्छा
neither party has
नहीं
No, oral evidence
आईओ
is there.
देखैची 800 meter ना कि
ଆଜ୍ଞା ଚଲା ବାଟଟା 800 ମିଟର ସେ ମଝିରେ ଲେଖା ହେଇଛି ଯୋଉଟା ମେନ୍ ରୋଡ ସେଟା ଲେଖା ହେଇଛି 3 କିଲୋମିଟର
କିନ୍ତୁ evidence
ବଟ୍ P5 ର ଖାଲି ଏଭିଡେନ୍ସ ରେ ଅଛି he has a two wheeler
yes
No,
he came
that
by
much.
motorcycle
he came by motorcycle से कहला ना मु सेही रास्ता रे गलिनी माने ये मारी किनी सेही रास्ता रे जाउतला तो से रास्ता रे न जाई कि
अलगा बाटे
सेपट अलगा बाटरे जाई किनी ताको information maybe information दबा
out of fear I went
Yes,
to the other route but in fact he had been to the land his bike was there but his evidence is ମୁଁ ବିଲରେ ଥିଲା ବେଳେ ମୁଁ ଦେଖିଲି ଆଗ ଡିସିସ୍ ଗଲା ତାପରେ followed by this accused main accused Naveen
कि PW5
this was coming
this has been given.
in a different direction both are moving I mean
Not-
Navin was going towards the village
Yes.
and he was coming from the village towards the cultivation land
Hmm.
and Navin was on the back of the P5 so he had a sound unusual sound so he looked back he found Navin is going on assaulting the deceased so then he started his motorcycle and came in a different route
okay then so you have covered this witness's statement medical evidence
yes
inquest anything you want to argue further on merit anything there in the IO's evidence to be placed
no plus I was consistent enough
formally all
Yes.
these things have
yes plus and that has been covered and so far as PW5 is concerned PW1 3 4
and today also Mr. Sarangi raised the point that about the safe custody of that Tangia and seized articles.
Tangia is safe
There was-
custody ନଥିଲା ବେଳେ ତାର ବାହାରୁନି ସେ ଏଇଟା ଗ୍ରୁପିଂ ଟା ହେଇପାରୁନି but it carries blood
No, about the other articles even जो गुड़ाकर आपण blood stain पाइले human blood stain पाइले
wearing apparel.
हाँ wearing apparel कारण एटा सब तो सेही दिन ही गला ना
ଆଜ୍ଞା।
ଆପଣଙ୍କର ସିଜର ହେଇଗଲା wearing apparel ସବୁ ଗୁଡାକ
ପରଦିନ
ପରଦିନ ହେଲା
ପୋଷ୍ଟମର୍ଟମ ହେଲା ପରେ ଡିସିଜ ମାନେ
ଆଚ୍ଛା,
wearing apparel
ମାନେ
ଆସିଲା
spent on
ଆଇ
night.
ହଁ 21-22
22
ଭିତରେ
ରେ ସିଜର ଗୁଡା
ହଁ।
ହେଲା
ଏଇଟା
ଟାଙ୍ଗିଆ
ଯାଇଛି ସବୁ 9
ମାଇ।
ତାରିଖରେ ଯାଇଛି ସେଣୁ ଆପଣ ପୋଲିସ ଷ୍ଟେସନରେ ରଖିଥିଲେ ପୋଲିସ ଷ୍ଟେସନରୁ ସେ କନଷ୍ଟେବଳ କହୁଛି ମୁଁ ସେଠୁ ନେଇକି ଗଲି ସେ ସେଫ କଷ୍ଟଡି ଉପରେ ଯୋଉ ଆର୍ଗୁମେଣ୍ଟ କରିଛନ୍ତି କିଛି କହିବାର ଅଛି ଆପଣଙ୍କୁ
କିଛି ବି କ୍ୱେଶ୍ଚିନ୍ ପଚାରିନା କୌଣସି ୱିଟନେସ୍ ସେ ରିଲେଟିଂ କ୍ୱେଶ୍ଚିନ୍ କିଛି ପଚାରାଇ
ଆଇଓ
ଇଭେନ୍ ଆୟକୁ ପଚାରାଇ
ଆଇଓ ପଚାରା
No.
ଆଇଓ କିନ୍ତୁ କହୁଛି ମୁଁ ଏକ୍ଜିବିଟ୍ସ ଗୁଡାକ ପୋଲିସ ଷ୍ଟେସନରେ ନେଇ ରଖିଲି କହିଛି ନା
No,
ନା
sir,
ନା ତା ଘରେ ନେଇ ରଖିଲା
let me read Schedule 20 or so.
ଏଇ ଯୋଉ ଗୁଡାକ ସିଜ୍ କଲା
Yes.
ସିଜର ଲିଷ୍ଟ ପ୍ରିପେୟାର କଲା ତାପରେ ସିଜ୍ଡ ଆର୍ଟିକଲ କୁ ସେ କଣ କଲା କହିବନି
ମୁଁ ପଢିବି ସେଟା I pray lordship to come to page 127. I had read up to paragraph 3.
No, you have read this in 4 also
yes.
you have placed 5 also you have
I read.
I think placed dead body ଚାଲାଣ ଫଲାଣ ଗଲା ପରା paragraph number 8 ରେ ଅଛି ସେ ଯୋଉ weapon of offense କଥା
I examined both the accused persons and arrested them. During interrogation, the accused Nabin Devi confessed his guilt that he has prolonged civil dispute with the deceased and out of anger he has killed all three deceased by means of an axe and concealed the weapon of offense inside a straw heap of his house. This being a statement subject to leading to discovery, I arranged two independent witnesses from village Lapoda, namely Sanjay Naik, who is PW 12, and Parameswar Khadia, PW 13. I recorded the statement of accused Nabin Devi in presence of the witnesses in a separate sheet. This is the said statement of the accused recorded under section 127 of Evidence Act, already marked as exhibit P14, and this is my signature on it. Thereafter, the accused Nabin led myself and the witnesses to his house. He went to the straw heap over the veranda of his house and brought out the weapon of offense. The axe kept inside the heap and produced the same before me in presence of the witnesses. I seized the same at the spot and prepared the seizure list. This is the said seizure list already marked exhibit P15, and this is my signature on. On the same day, I returned to the PS and seized the wearing apparels of both the accused persons
এই
under
ପଏଣ୍ଟରେ ଯୋଉ witnesses
under
ମାନେ ଅଛନ୍ତି
separate
କିଏ
seizure
କିଏ?
lists.
ଏଇ ପଏଣ୍ଟରେ ଯୋଉ witnesses ମାନେ ଅଛନ୍ତି କିଏ କିଏ independent witness ବା ଯାହା
12 and 13.
12 and 13.
PW 12 and 30
You'll also get it page 106 and 109.
ଠିକ ଅଛି ନାଇଁ ଖାଲି just ଜାଣିବାକୁ ଆମେ ପଢିଥିଲୁ ତ ସେଇଟା ଦେଖି ଇଏ ତାପରେ
On the paragraph 9.
ହଁ
On the same day, I returned to the PS and seized the wearing apparels of both the accused persons under separate seizure lists. This is the said seizure list in respect of seizure of the wearing apparels of accused Nabin, already marked as exhibit P16, and this is my signature on it. This is the said seizure list in respect of seizure of the wearing apparels of accused Hemanand, already marked as exhibit P17, and this is my signature. I sent both the accused persons for their medical examination to S.D.H. Kuchinda, as well as for collection of hair of their biological materials. The staff of the police, namely Jayadev Maji and Namita Kerketa, returned to the PS with the biological materials of the deceased and their wearing apparels. On production, I seized the biological materials and the wearing apparels of all the three deceased. This is the said seizure list already marked as exhibit P20, and this is my signature on it, marked exhibit P20 by 3. The SI Dilip Kumar Behra, it is P16, returned to the PS with the biological materials of both the accused persons from SDS Kuchinda. I seized the same and prepared the seizure list at the PS. This is the said seizure list already marked as exhibit P19, that is available at page 261. And this is my signature on it. I forwarded the accused person to the court. During investigation on 23rd 10 2020, I revisited the spot and prepared 3 spot maps showing the connection between 3 spots where the dead bodies were lying separately, and to ventilate the court in which manner the murder has been committed. This is the crime detail form marked exhibit P25 that you will also get at page 263. And this is my signature on it. This is the spot map in 3 sheets marked exhibit P26. That is available at page 271. 26 by 1, 26 by 2 respectively. Before visiting the spot, I sent the wearing apparels of the accused persons and the weapon of offense to DFSL Sambalpur for UV light test. On 24/10/2020, I issued requisition to Tahsildar Bamra for demarcation of the spot. This is the said letter, marked Exhibit 27, available at page 274 loss. And this is my signature on it. On the same day, I went to DFSL Sambalpur and seized the material collected by the scientific officer DFSL Sambalpur and prepared the scissor list. I received the weapon of offense, wearing apparels of the accused, and the weapon from the DFSL Sambalpur. This is the scissor list in respect of the materials collected by DFSL Sambalpur, already marked as Exhibit P11, available at page 256. And this is my signature marked as Exhibit P11 by 3. This is the said UV light report, already marked as Exhibit P13. On 25/10/2020, I seized the documents relating to the land dispute between both the parties on production by one Uday Chandra Puset, PW2 loss. This is the said scissor list, already marked as Exhibit P5, and this is my signature on it. I left those documents in Jimma of Uday Chandra Puset. This is the Jimma Nama. On 2nd November 2020, I received the PM report of all the three deceased. On 3rd 11/2020, I issued requisition query to the officer who has conducted PM over the dead body of the deceased persons and also produced the weapon of offense before him with a prayer to submit the report whether the injuries sustained by all three deceased are possible by the said weapon. This is the said written query, already marked as Exhibit P10, and this is my signature on it. On the same day, I received the opinion reflected on the reverse side of the query, already marked. Already your lodge was seen. On 9/11/2020, I sent the material objects, wearing apparels, weapon of offense, and biological materials of the accused persons and the deceased to RFSL Sambalpur for chemical examination. This is the said forwarding report of SDGM Kuchinda, marked as Exhibit P28, that is available at page 140. This is my prayer to the court, and this is my signature on it. On 17/11/2021, I received the spot demarcation report from Tahsildar Bamra. This is the said report, marked as Exhibit P30. I received the spot, that P30 is available at page 274. I received the spot visit report of DFSL Sambalpur. This is the said report. This is the chemical examination report of RFSL Sambalpur, marked as Exhibit P31. That is at page 146 to 150. During investigation, I have also examined the witnesses. After completion of investigation, I submitted charge sheet against the accused person for commission of the offence under section 302/34 of IPC. This is the said acts, already marked as MO1. This is the lungi of the accused.
Mr. Patkia, not a single line has been stated by the IO that what he did with the seized articles.
It's a
We have
process.
already
After the seizure, he must have brought it.
Yes,
to the
There
police
must be a
station.
Malkhana number,
Yes.
case Malkhana number. He is not giving this. It's a,
It is definitely
He
it is a
taku
latches
dekhna.
on the part of the prosecution. The court also should have made very alert on this thing. We have already checked it. Not a single line has been stated
yes.
that he kept it after seizure, either the acts or those things in the police
he brought
Malkhana.
it to the police
କାରଣ
station.
ଆପଣଙ୍କର ଗ୍ୟାପଟା ହେଇଯାଉଛି ଦେଖନ୍ତୁ 21 ରେ ହେଲାଣି ଆପଣ 9 ତାରିଖରେ ମାନେ ପାଖାପାଖି 15 ଦିନ ଗ୍ୟାପ ହେଇଯାଉଛି 15 ଦିନ ଭିତରେ ଆପଣ ସେଫ କଷ୍ଟଡିରେ ଯଦି ନ ରଖିବାକୁ ଏଭିଡେନ୍ସ ହିଁ ନଦେବେ ତାହେଲେ ଯୋଉଟା ପଠଉଛନ୍ତି ତାର ଏଭିଡେନ୍ସିଆରି ଭ୍ୟାଲ୍ୟୁ କଣ ଆସିବ ହଁ ତାର କୋଉଠୁ କଣ ରକ୍ତ ମିଳିଲା ଅମୁକ କଲା ହଁ ତେଣୁ it is the duty of the prosecution and ଯଦି ଆପଣ ସେ ବିଷୟରେ ପଚାରୁନାହାନ୍ତି ସିଏ କଣ ପାଇଁ ତା ଉପରେ ଜେରା କରିବେ ଆପଣ ସିନା କହିଥିଲେ ଏମିତି ମୁଁ ରଖିଲି ଏ ଜେରା କରିଥାନ୍ତେ ଆପଣ ଯଦି ପଚାରିବେନି it is your duty that if these articles were kept in safe custody there was no chance of tampering with the same and till it was sent for C examination ତେଣୁ ଆପଣ ଆଣିଲେ ଖାଲି ସିଜ୍ କରିଦେଲେ ତାପରେ ଆଉ ଗୋଟେ ଏଭିଡେନ୍ସ ଦଉଛନ୍ତି ଆମେ ତାକୁ ପଠେଇଦେଲୁ ଅମୁକ ତାରିଖରେ ତାପରେ ସି ରିପୋର୍ଟ ମିଳିଗଲା ଆଉ ସେ ଯୋଉ ଜିନିଷ ଗୁଡା ପଠେଇଥିଲୁ ସେଗୁଡାକ ଫେରି ଆସିଲା ମଧ୍ୟ ଏଇଟା ହଉଛି ଆକ୍ସ ଏଇଟା ହଉଛି କପଡା ଏଇଟା ହଉଛି ଏ ଯୋଉଟାକ ମାର୍କ କରିଦେଲେ ଏମଓ ହିସାବରେ but the main thing which is arguing ଯେ ଆପଣଙ୍କର where is the evidence of keeping these seized exhibits in safe custody that should have been some evidence has to be
Evidence must
adduced
have.
ଆପଣ ମାଲଖାନା register produce କରନ୍ତୁ ନ କରନ୍ତୁ, that's a different matter.
course.
But at least something should have been stated by that IU.
Well, on the face of the cleansing materials,
No,
No,
here
we are not.
we are
yeah,
not on
this
that.
is a procedure.
Once
That can
the-
put out the entire prosecution.
Here, unless
Yeah.
that is exactly we said that once the eyewitnesses' statement are not demolished, these things
Yes.
would have assumed importance. Suppose it would have been a case under NDPS.
Yes, then
ହେଲା
yes.
ତେଣୁ ଏମିତିଆ ଜିନିଷ ଆସିଥାନ୍ତା, କିଛି ଏଭିଡେନ୍ସ ନାହିଁ, କୋଉଠି ରହିଲା, କଣ ହେଲା, କାହା ପାଖରେ ରହିଲା, ଏଇଟା
Yes.
କିନ୍ତୁ ଏଠି ଯୋଉ ଆଇ ୱିଟନେସ୍ ରହିଯାଉଛନ୍ତି, ଏଠି ମ୍ୟାକ୍ସିମମ୍ ଆମେ ୱେଟ୍ ନ ଦେଇ ପାରୁ
Yes.
ସି
Even
ଏକ୍ସାମିନେସନ,
C report, chemical examination ନ ଦେଲେ ବି
ଏକ୍ସକ୍ଲୁଡ କରିଦେଲେ ବି କଣ ହଉଛି, ସେଇଟା ହଉଛି
and state of PP versus Krishna Master, in that judgment already the Honorable Apex Court has said that in every prosecution case, each prosecution case, there
No,
carry some latches.
there is
No prosecution case is free from any latches.
how far that latches has affected the
Yes,
prosecution
case,
case, that is to be seen.
Now, this is the question we are just putting,
Yes, yes,
showing the diligence
Yes,
of either the
yes.
prosecution
Yes.
or the court.
Yes.
Court must remain alive.
Yes.
After the seizure, where did you keep it? What is the Malkhana number? Once that evidence comes, nothing. That's all.
କୋର୍ଟଟା ତ ଖାଲି ଖାଲି ଟାଇପ କରିବା ପାଇଁ, ମାନେ ରେକର୍ଡିଂ ମେସିନ ନୁହେଁ ନା, ଯାହା ଇଏ କହିବ ସେ କହିବ।
Recorded that question by court.
Court.
ହଁ,
That is
ହଁ,
separately
ହଁ,
recorded.
କୋର୍ଟର ଡ୍ୟୁଟି ଅଛି ଇଣ୍ଟରଫିୟର
Yes,
କରିବାକୁ, ଇଏ କରିବାକୁ,
every part interpreted.
ଫାଲତୁ କୋଶ୍ଚିନ୍ ହେଲେ ଇଣ୍ଟରଫିୟର
Yes.
କରିବ। 165 ର ଯୋଉ ଡ୍ୟୁଟି ଦିଆହେଇଛି, ଯୋଉ ଟୁ ନୋ ଦି ଟ୍ରୁଥ, କୋର୍ଟ କ୍ୟାନ୍ ଅଲସୋ ଏକ୍ସାମିନ
Yeah.
ୱିଟନେସ୍, କୋର୍ଟ ୱିଟନେସ୍ ହିସାବରେ ଆରାଇଭ୍ ଆଟ୍ ଦି ଟ୍ରୁଥ, ମେନି
Yes.
ଥିଙ୍ଗସ୍ ପାୱାର ଅଛି।
Court has every power.
ସାର୍ ଚୁପଚାପ ବସିକିନି ସାଇଲେଣ୍ଟଲି ଖାଲି ଇଏ କହିଲା ଏୟା ରେକର୍ଡିଂ କରିଦେ, ସିଏ ଏଗୁଡାକ this is one type of thing. Another set of thing is that it is usually there is complaint that counsel ଯଦି cross examination ରେ କଣ ପଚାରିବେ, ଏଇଟା କାଇଁ ପଚାରୁଛ, ଆଦେରେ କଣ ମାନେ law ଦେଖାଅ, so that should not be also the
Yes.
attitude. ମାନେ court ର trial court ର ଯୋଉ duty ଟା
Yes.
ରହୁଛି, ସେ ମାନେ man is facing the trial where death sentences or life imprisonment, ଆପଣ ପୁରା alert ରହିବା କଥା। ହଁ, ଆପଣ ଦେଖନ୍ତୁ ଏଇ କେସ୍ ରେ ଏଇ ଯୋଉ ଜେରା କରିକିନି ତାକୁ କନଫ୍ରଣ୍ଟ
Yes.
କରିଛନ୍ତି,
Yes.
ଟିକେ alert ରହିଥିଲେ ଏଗୁଡାକ ଲେଖା ହେଇଛି ନା 161 ଅଛି,
Right.
ତାକୁ ଡିଫେନ୍ସ କାଉନସିଲ ପଚାରୁଛନ୍ତି ଯେ ନାଇଁ ତମେ 161 ରେ କହିନ, ତାକୁ ରେକର୍ଡିଂ ହେଇ ଚାଲିଛି, नो इट्स नॉट ए फैक्ट, यू हैव नॉट स्टेट। ହଁ, ଟିକେ ଯଦି ବି alert ହେଇଥାନ୍ତା, ଆଇଦର ସିଏ କୋର୍ଟ alert ହୁଅନ୍ତୁ ବା
Prosecution.
prosecution alert, ଏ ଭୁଲ ହେଇନଥାନ୍ତା। ହଁ, ସେଇଥିପାଇଁ କଣ୍ଟିନ୍ୟୁଅସଲି ସେଟା କୁହାହଉଛି ଯେ ନାଇଁ court should remain alert, court is not a recording
Yes.
machine. Yes, next.
ଆଉ ଟିକେ ଏକ୍ସାମିନ କରିବି ସେ କେମିକାଲ ଏକ୍ସାମିନ ରିପୋର୍ଟଟାକୁ, ଆଉ ଯଦି କିଛି ଥିବ 15 ମିନିଟ୍ ସାରିଦେବି।
24 ତାରିଖ ରଖିବାକୁ କହୁଛନ୍ତି ନା ଏକାଥରେ ଆସିଲା ପରେ? So I think that the order which we are passing today for collecting all those materials, it may take at least 2 weeks time to you.
Yes.
So we are fixing it in the week commencing. Let us fix it on 10th of July,
Yes.
24.
Yes.
So that by the time you collect all the information, they also are likely to file the affidavits.
You will conclude it.
Right.
We can conclude it on 24th, on Monday.
No,
On Monday,
it cannot be concluded totally.
Argument conclude कर दो।
Argument ଆପଣ merit ରେ, but death sentence argument ଟା ହବ after receipt of the report. But we are passing that order today about the collecting, so that immediate step can be taken. The persons are there,
death sentence argument in advance kahi hei paribani, of course subject to lordship's appreciation.
No, let it come. कारण ସବୁ ଜିନିଷ ଆପଣ ପାଖରେ ଆସିଲେ ଆପଣ mitigating circumstance ର ଆପଣ ଜାଣି ନାହାନ୍ତି ଏଠି ତ କିଛି ଲେଖିନି ନା ଆପଣ have you seen?
In fact, for mitigation, there is no material at all.
ତେଣୁ ସେଇ ଯୋଉ ଜିନିଷ ଗୁଡାକ ଆସିବ ତା ଦେହରୁ ହିଁ mitigating circumstance ବହୁତ ବାହାରି ପାରିବ
Yes.
ତେଣୁ ସେଗୁଡାକ ଯଦି ଆସିଲା ଯୋଉଟା କି ଆମକୁ କୁହା ମାନେ କୋର୍ଟ ର ଭ୍ୟୁ ହଉଛି ଯେ ତାକୁ ଆପଣ କନସିଡର କରିବେ right from Bachchan Singh's case mitigating circumstance କୁ ଆପଣ omit କରିପାରିବେ ନାହିଁ ହଁ mitigating circumstance କୁ ଆପଣଙ୍କୁ consider କରିବାକୁ ପଡିବ ଏଠି ଯଦି କୋର୍ଟ ର ଡ୍ୟୁଟି ହଉଛି ଯଦି mitigating circumstances ର କିଛି material ଆସିନି ଟ୍ରାଏଲ କୋର୍ଟ ରେ appealate କୋର୍ଟ ର ଡ୍ୟୁଟି ହଉଛି ଯେ ତାଙ୍କୁ opportunity ଦବା କଥା ବା prosecution through ରେ ଏଇ ଜିନିଷ ଗୁଡାକ ଆଣିବା କଥା ତାର conduct କଣ ଇଏ କଣ ସେ କେମିତି ତାର background କଣ ଅଛି ଏ ସବୁ ଜିନିଷ ଆସିଲା ପରେ that can be so you can conclude your argument on this merit we'll hear about the death sentence after receipt of this report as per the order which you are passing today okay so we this matter will be taken up obviously it will come on the list on 24
Yes.
okay ଏଇ ସବୁ 24th ରେ ପାର୍ଟ ଆଡ କରି ରଖିବେ ହେଲା so ଆଜିର ଏଇ ଫାଇଲ ସାଙ୍ଗରେ ପାଖକୁ ଯିବ so today we are rising
And coincidentally, Millers, that is also a decision of Sambalpur. That
What?
95-8 OCR.
ଓ ସେଇ ଯୋଉ ଛୁଆ ଯୋଉ ତିନିଟା
That is also a Kuchinda.
ହଁ ତିନିଟା ଛୁଆ ମର୍ଡର ହେଇଥିଲା